My please, Lordship. Lordship, item number 10, Lordship. The petitioner was expired, Lordship. This is the instructions.
Yes. When
Petitioner
did he
was died,
expire?
4 years back, Lordship.
Abated. It is submitted that Ms. R. Rangmai, Learned Counsel for the petitioner, submits that during the pendency of the present petition, around 4 years back, the petitioner had passed on. So, however, she submits that nobody in the family had come forward for substitution. For substituting themselves in place of the present petition. Accordingly, she submits that the present petition has become abated. So, in view of the above submission, the present petition goes on being abated.
Much obliged.
May please, Your Lordship. But item number 40, my lord. Item number 40. This matter has come before Your Lordship. But my lord, this matter was heard by Honorable Mr. Justice, my lord, Jahana Khan. So, my lord.
You want it there?
Lordship may.
No. If it is heard,
Yes, my lord, Lordship has already heard.
okay. It is submitted that
As per the
matter,
my lord.
present petition 40. Mr. S.P. Das, Learned Counsel for the petitioner, submits that the present matter was heard at length by a coordinate bench. I cannot live here. Yes.
Sahi, madam.
Samima, degree. So accordingly, registry to verify the set position and list the matter before the appropriate bench.
But as per order 46.
Heard the matter on 4/6/20.
46, madam.
May I please, Your Lordship? Well, I beg to mention for listing similar matters, Your Lordship was pleased to fixed on.
Go before the
My lord.
main senior bench.
No.
May I please, Lordship? Lordship, item 48 today. It was heard on the last day,
Today we are contemplating to pass an order, provided time permits.
Lordship.
May it please your Lordship. Lordship, in item number 31, on the last occasion, Lordship had given us the liberty to mention it for fixing it at 2 p.m. Lordship.
When did I give any? I don't give any such.
Orally, Lordship. Kindly,
I have not passed any order, so how can you bind me with?
Lordship, kindly at 2 p.m. Lordship.
If not kindly, Duta Wazar Madhuri.
Much obliged.
15 minutes, he said. Beyond 15 minutes, I'll not hear the matter.
Lordship. Much obliged, Lordship.
Mr. Amen, we'll continue with the dictation after we finish the top of the list items.
I need to excuse Lordship. On the occasion I left the Mr. Miller. I am suffering from the side
Please don't.
along with the old age.
You're not old.
My lord,
You withdraw that statement.
Lordship, my humble suffering for Lordship, my lord. I am deprived of fair hearing on earlier occasion, my lord. Petitioner is deprived of fair hearing.
Yeah, we have heard you
No,
fairly.
Lordship, I'm not accusing your Lordship, my lord.
Then?
Because my lord, Lordship is aware that the purpose
Okay.
of
Today you make your submissions when the matter is called up.
Lordship. Lordship,
Clearly.
only one thing, my lord, from till date, no para was reply given by that. Last 10 years, my lord.
We will
So,
consider.
I may be allowed to
everything.
submit.
If you have anything further to add, please come down.
Lordship.
That much we will not deprive you.
Lordship.
Yeah. Next.
7.
Yes, Mr. Vachaji.
Lordship. His conviction was now he is in criminal appeals he was acquitted, Lordship. But in earlier occasion, Lordship, he was dismissed from service, Lordship, under the Article 311 sub rule 2, Lordship, by the Constitution of India, Lordship. There is some exceptional there, Lordship.
None appears for the petitioner on call. The petitioner in the present petition has presented a challenge to an order dated 7/1/2014 issued by the Superintendent of Police, Baska Musalpur, dismissing the petitioner from his services. Basing on his conviction in criminal case, by conviction
GR case number.
in Sessions case number 42/2012. Basing on his conviction, by judgment and order dated 4/1/2014 passed by the Court of the Assistant Session Judge Nalbari in Sessions case number 42/2012. Also, the ground of challenge, the challenge is presented on the ground that the petitioner, so and so, full stop. As projected in the petition, the petitioner, basing on an FIR lodged against him, which was registered as Tamulpur PS case number 109/2010 under section 376 bracketed 2 bracketed small a IPC. Also, as projected in the writ petition, an FIR was lodged against the petitioner on 29/7/2010 by one Maloti Kalandi, inter alia alleging therein that the petitioner had raped her. Also, the said FIR was registered as Tamulpur PS case number 109/2010 under section 376(2) bracketed A bracketed 1 IPC. The police, on conclusion of the investigation, submitted a charge sheet against the petitioner under section 376(2) bracketed A bracketed 1 IPC. So, thereafter, a trial ensued in the matter. On conclusion of the trial, the Court of the Court of Assistant Session Judge Nalbari, by judgment and order dated 4/1/2014, basing on the evidences coming on record in the trial, proceeded to convict the petitioner. Under section 376(2) bracketed A bracketed Roman ID bracket over IPC, and sentence him to undergo rigorous imprisonment for 10 years, along with payment of fine of ₹10,000 only in default, to undergo simple imprisonment for 6 months. You are appearing in this case?
Yes, Lordship.
6 months. Also, the petitioner being aggrieved, in pursuance to his conviction by the learned trial court, the Superintendent of Police, Baska, Musalpur, by order dated 7/1/2014, proceeded to dismiss the petitioner from his service on account of the misconduct committed by him, which had led to his conviction in a criminal proceeding. Also, the petitioner, being aggrieved, had instituted the present writ petition. Also, the learned counsel for the petitioner has submitted that the decision that the judgment and order dated so and so dated 4/1/2014 passed by the learned assistant session judge Nolbari in sessions case number 42/2012 was assailed by the petitioner before this court by way of instituting a criminal appeal, being criminal appeal number 26/2014. This court wide order dated 30/10/2025 on considering the issues arising in the said appeal proceedings to interfere with the said decision of the judgment and order of the learned trial court, and the appellant was acquitted of the charges framed against him under section 376(2)(a) IPC. Also, the learned counsel for the petitioner submits that the petitioner being imposed with the penalty of dismissal from service only on account of his misconduct, which led to his conviction in a criminal case. The said conviction having been interfered in an appeal by this court, the very ground for imposition of the penalty of dismissal from service upon the petitioner stood removed, and accordingly, the order dated 7/1/2014 would mandate an interference from this court. Mr. A. Bhakshaji, learned government advocate, appearing, A. Chakraborty, learned counsel, for appearing for the learned state counsel, learned government advocate appearing for the respondents, has submitted that the petitioner was removed from his services while the order dated 7/1/2014 only basing on his conviction in the criminal proceedings instituted against him. It is submitted that this court in an appeal having interfered with the judgment and order, the conviction of the petitioner, the order dated 7/1/2014 would not mandate, would mandate an interference. However, he submits that the petitioner, not being in service with effect from 7/1/2014 on account of the imposition of the penalty upon him, and presently the petitioner, you have superannuated.
Yes.
Petitioner having superannuated from his services, this court would be pleased to direct that the petitioner would not be entitled to any arrears of salary for the period with effect from 7/1/2014 till the date of his superannuation. Also, as the petitioner had admittedly not discharged any duties during the said period. I've heard the counsel for the parties and also perused the materials a bit recorded. The conviction of the petitioner by the learned trial court wide judgment and order dated 4/1/2014 in passed in sessions case number 42/2012 had led to the issuance of the order dated 7/1/2014, imposing upon him a penalty of dismissal from service by invoking Constitution. By invoking the provisions of section, article 311 2 bracketed A. Also, the conviction of the petitioner having been interfered with by this court in wide order dated 13/10/2025 in appeal number 26/14/14, and having acquitted him from the charges so framed against him in criminal proceedings instituted against him, the very basis for issuance of the order dated 7/1/2014 should removed. Accordingly, the order dated 7/1/2014 being found to have been issued only on account of the conviction of in the criminal proceedings instituted, on the acquittal of the petition by this court, the said order dated 7/1/2014 would mandate an interference. Accordingly, the order dated 7/1/2014 stands set aside. Having interfered with the said order dated 7/1/2014, this court, on finding that the petitioner was not discharging his duties after the imposition of the penalty of the order, after the issuance of the order dated 7/1/2014, till the date of his superannuation, which had occasioned on 30/6/2014, this court directs that the petition would not be entitled to any pension, and pension would not be entitled. Would be entitled all salaries for the set period. For the period with effect from 7/1/2014 to 30/6/2014. Also, the respondent authorities accordingly shall fix the pay of the petitioner as on 7/1/2014 and thereafter compute the arrears of pay that would now be receivable by the petitioner till the date of his superannuation, which had occasioned on 30/6/2014, and release the same to the petitioner within a period of 6 months from the date of receipt of a certified copy of this order. On the salaries of the petitioner being released, being computed and fixed for the period 7/1/20 to 30/6/2004, the respondent authorities shall prepare about 3 months ago, shall prepare a pension proposal in respect of the petitioner and submit the same to the office of the Accountant General within a further period of 3 months. Also, the office of the Accountant General, on receipt of such pension proposal in respect of the services rendered by the petitioner, shall further process the same and disburse to the petitioner his pension and pensionary benefits within a further period of 3 months from the date of receipt of a certified copy of this order. With the above observations and directions, the present petition stands disposed. Yes. Selection is of
2010,
we are today in 2016,
26.
26, sorry, 26.
Yes, sir.
Then,
In the affidavit in reply, we have said, Miller,
oh,
there are 49 posts are still vacant in the department. Otherwise, prima facie, there is gross illegalities in the election.
they have clarified that in the second, after your matter was remanded. This court did not say anything, just remanded the matter back to the.
With some observation.
That observation is observation made in air. We can say, I can use that word, because there was no material before this court.
Yes, Miller. In
So-
spite of the repeated order, they did not produce the record.
Then the respondents considered that, passed a very detailed order.
Even then, Miller, that it is in violation of
And
the rule.
today you are beyond the age of appointment.
In item number 9, perhaps he is in within the limit. My lord, even the second impugn order, my lord, it speaks, my lord, it is beyond the purview of the rule, my lord. They cannot pass an order without the approval of the board, selection board as constituted under rule
They
7.
have done it because where will they get that selection board now? They'll not get that selection committee. So they have you alleged malafide? So
Yes,
have you alleged malafide?
yes, my lord.
Where? Against whom? What are your submissions?
But I have tried to make out that synopsis in terms of the last order. I have supplied the copy of synopsis yesterday, my lord.
Oh, one more beggar.
In the second case, my lord, your lordship may take up WBC 5701. my lord.
Let us see the earlier order of this court. Yes.
My lord, that this direct recruitment for field assistant is governed by the Assam Economic and Statistical Junior Service Rule 1980. my lord. The board in terms of section 2, rule 2B, board means the selection board constituted under rule 17. Rule 17 is prescribed the board, my lord. And the rule 6, my lord, your lordship will see the copy of the resolution.
Hmm.
The board constitute of rule 17, your lordship will see the board, my lord. Selection board. The board referred into Rule 6, 11, 12, and 13 shall consist of the following: the Director of Economics and Statistics, Senior Most Joint Director of Economics and Statistics, a Deputy Secretary, Under Secretary nominated
What
by
is the manner of selection, procedure for selection? Where do I get it?
my lord. Lordship will see that the Rule 6 direct recruitment procedure is laid down. I have also quoted the rule, my lord.
Mm-hmm.
Synopsis that issue organized. Rule 6.
It says only interview.
My lord.
Then why was a written test held?
There were 100 marks of written test and vivacity of 30 marks.
So, but the rule says only interview.
My lord, and lordship, if lordship will see is 6, 1C and D, my lord. It is the board to take a decision, my lord. The subsequent re-evaluation, it doesn't speak about that there is a agreement or approval by the board, my lord. They have done of it of their own, my lord.
Let us come to the order of this court.
My lord. Starts at is 44.
Conclusions,
Conclusions, the lordship will find, my
page
lord.
51.
Yes, my lord. Two, three paragraph of the judgment,
Para 8.
Paragraph 7 onwards.
Is that the records have not produced in
No,
spite
my
of deputy?
No, my lord. Paragraph 7, your lordship will
You
see,
may
my
have
lord.
received a record.
Paragraph 7 relates to not production of the records, my lord. Paragraph 9 and 10, your lordship will see. Paragraph 9. As has been brought on record, the cutoff mark for selection and appointment of general category.
No, seven.
Paragraph
Eight,
7.
eight, eight.
8 million. As stated, the writ petitioner being 433, he is not before this court this time.
He's not there.
No, my lord.
So we'll go to the person who is there.
Yes, my lord, I have marked WBC 6413, middle of
What is his name?
6413. He was Jyotirmoy, this present petition in 5701.
Moy.
Chaudhary. Fifth line from the top, my lord. 8, paragraph 8. My lord.
Hmm.
Similarly, the petitioner involved in WPC 6413 of 2010 has also been provided with a lesser mark at the subsequent stage in a vivace segment of the selection, as has been contended by the said petitioner as against the original 24.5 marks secured by him in the vivace segment. The same was subsequently reduced to 23. In WPC 6414, the other
Just
person
no. This is 24.5.
to reduce to 23.
So this is the only grievance you have.
My lord, in respect of this petitioner.
Okay. Then how many petitions are there? Two.
Two petitioner in two cases, my lord.
And with regard to
In
the other one,
in WPC 6414, that item number 8
what is
now.
his name?
His name is Osim Bormon, my lord. WPC 5693.
Osim.
Yes, my lord. The
Osim
petitioner
Bormon.
secured 80 marks in the written examination, which was subsequently reduced to 76. Similarly, in vivace segment, also the mark secured
Marks
by him,
reduced to
76, my lord.
and Viva Vuse.
And similarly, in the vivace segment, also the mark secured by him, 24, was reduced to 15, my lord, at the later stage.
24 to-
In the other writ petition, that will not, he is not before the
So
court.
these are the two we want to.
My
do.
lord,
So in the first case, it is
in the vivace,
24.5 to 23.
my lord.
And in Osim Bormon, there are two grounds, 80 to 76 and Viva 24 to 50.
My lord. Now your lordship will come to paragraph 9. It has been brought on record the cutoff mark for selection and appointment of for general category.
Both are OBC or
No,
general?
my lord, in item number 9, he is general candidate.
No, tell me the name. Osim is general,
Osim is OBC
OBC.
and Jyotirmoy is general.
So general cutoff was 104
104,
and OBC.
99.5.
Hmm.
It has been brought on record the cutoff mark for selection and appointment for general category candidates was fixed at 104 and OBC category candidate was fixed at 99.5. This has been stated in paragraph 8 of the counter affidavit filed by the respondent number 2. If we go by this said cutoff marks and the original marks secured by the petitioner are maintained, then the petitioner involved in WPC 433 would have secured, I'm my lord, skipping my lord, this, he is not before the court, my lord. The petitioner in WPC 6413.
That is Jyotirmoy.
The Jyotirmoy, my lord, would have secured 80 plus 24.5, 104.5 bucks, man. Second line, my lord.
But you say that he secured 24.100.
My lord. The petitioner in WPC 6414 of 2010, the C, my lord, would have secured 80 plus 24 is equal 104. B,
So both of them come above the cutoff mark.
yes, my lord. P, it stated here that the below, he belongs to OBC category. Lastly, the petitioner in WPC so-and-so would have secured, he is not before the court, my lord. Now, lordship will see next paragraph, my lord. If we go by the above calculation in reference to the cutoff marks for selection and appointment, the petitioner in WPC 6413 of 2010, my lord, Jyotirmoy, namely Jyotirmoy Chaudhary, and the petitioner involved in WPC 6414 of 2010, namely Osim Bormon, would have made the final stage of appointment. This is the observation by the honorable court. Lordship will see the next paragraph at paragraph 11, my lord. This is also important, my lord. Above aspect of the matter will be considered in reference to the stand of the respondents in their counter affidavit regarding reduction of mark. In paragraph 4 of the counter affidavit, while admitting the original mark secured by the said two petitioners, it has been stated that the answer script of the candidates securing 70 marks and above has been re-examined and on sample basis. It has also been stated that to avoid any allegation of bias approach, all the answer script securing 70 marks and above had been re-examined. Upon such re-examination and depending upon the methodology in the answering question, spelling mistake, mistake of totaling, etc., the same of the answer script total marks secured by the candidates had been reduced. Next sentence is important, my lord. However, there is nothing to indicate that any decision was taken by the selection board to adopt this said procedure. This is also there is no also.
Okay, fine. Now let us come to para 14.
My lord.
Their direction is to the respondent number 2.
My lord.
Hmm?
All the requisitions are disposed of directing the respondent number, more particularly the respondent number 2, to examine the case of the petitioner in
Who is
reference to
respondent number 2?
the director. To the available material and consistently with the observation made above, and thereafter pass an appropriate order. Let the required exercise be terms in terms
So
of.
now let us come to the order
My
passed
lord.
by the
There is the grievance. That is the grievance. That has been done.
50.
Yes. May I read, my lord?
Yes.
Uh,
So this is under challenge.
my lord. With reference to your petition dated so and so, it is to inform that as per the common judgment and order passed by the Honorable Court dated 19/8/2014, a team of officers, my lord, that is my lord, under silence, my lord. Team of officers of the directorate have engaged to conduct the joint examination of the answer script of the written examination of all 4 petitioners, including you. My lord, this is in violation of Rule 6, my lord. There is no record to substantiate that this was with the approval of the board was taken, my lord. This examination. That cannot be undertaken without the approval of the board in terms of Rule 6, my lord. And the affidavit also, my lord, your lordship, I will go to show, my lord, there is nothing on record to show that they have taken approval of the board, well, in doing so. Now, your lordship will find point number 1, my lord. During joint examination, your answer script and mark secured by you has been decreased to 75. Now it is 75, my lord. Initially, it was 80, my lord. After this impugned order, it becomes 75. From earlier evaluated 79.5, my lord. This is also disputed because in the affidavit, in the earlier round, he says that he secured 80 marks. In the impugned order, it reflected as 79.5. I'll go to show them. I'll show your lordship that he stated that he secured 80 marks. The joint re-examination detected grammatical mistake in respect of the sentence construction in English, partially corrected answer with spelling mistake in general knowledge, adopted wrong procedure during mathematical calculation, and not use the proper mathematical sign during calculation in mathematics part, for which total marks were reduced from 79.5.
What about the other one? Osim?
Yes, ma'am. Last page, that was 59. His marks were increased, my lord. They stated that he secured 75 marks. Now it is 77.5.
So it is not only decreasing, it is increasing also.
Increasing also. My lord, either decrease or increase. This evaluation itself illegal because there is no approval of the board.
And 15 marks in
My lord, it has been said to be maintained, my lord, in Viva Hostel. Now, if your lordship will see the counter affidavit filed by the director in WBCS 5701, my lord. Only one document I will show.
Yes, where is the records, Mr.?
Record, yes, my lord. The voluminous record, my lord, today I
Give me
cannot,
they're just the answer script.
I cannot assist you, lord. But these are the records, my lord, today I cannot.
Find out the answer script
So skip.
and the
Viva Hostel.
Beba Bosi marking.
My lord.
This much only we got to see.
Yes.
Mr. Chutia,
My lord,
we'll take it up after some time.
yes,
You just go.
I will go through it, my lord.
Well, at 2 p.m.
No. 2 p.m. I've kept something before 2 p.m.
My lord.
When I are ready, just inform Mr. Hazarika. Mr. Chutia,
I'm here, my lord.
ask your junior to go through it once nicely.
Published.
Lordship, please, Lordship, I would not like to press this motion.
Mr. M. Bhagavati, learned counsel for the petitioner, submits on instruction that the petitioner desires not to press the matter any further. Accordingly, the present writ petition stands dismissed, withdrawn.
Much. Our name will be for that.
Huh?
Our
Mr. M. Upadhyay, learned counsel for the irrigation department is present.
obliged.
Yes, what is your stand here?
He was a part-time worker, Lordship. As far our affidavit is concerned, Lordship, it is stated that he was a part-time worker, Lordship, and grade initially grade pay was rupees 900, Lordship. Then it was increased to 2,500, Lordship. His claim
Have you
as
said that he is a part-time worker?
part-time worker, Lordship, in para 7, Lordship, in our affidavit in opposition.
Yes, Mr.
Lordship, in 2012, government took a stand, Lordship, not to engage sweeper, Lordship, on permanent basis, Lordship.
But whether he is continuing as on date,
Continue kori ache na? That instruction I have.
that if he is continuing that decision goes, then at least the minimum has to be given to him, that much.
Yes.
He will not be entitled to a regularization because he is post 1493. But that minimum pay, how can you deny? We'll wait for some time. Let's see if something comes. But this is your claim is that after 2012,
Or in 2012, Lordship, that is not that notification, Lordship. It's a
no.
different notification.
that all super these things will be outsourced.
Except media hospitals, Lordship, will be engaged on outsourced, Lordship. That is the exact wording.
Nobody comes, we'll dismiss it.
My lord, maybe after some time, Okay.
Your day.
Yes, my
How is this petition maintainable here?
lord. My lord, this
He is a civilian under the railways.
my lord.
If it is railways, it is the Central Administrative Tribunal, not here.
That was already admitted, my lord.
I don't have jurisdiction to consider after the decision in Elton. I can't confer jurisdiction on myself. No court can confer jurisdiction. You will have to go before the Central Administrative Court.
There are some, my
A
lord.
question of jurisdiction can be taken up at any point. There are
Otherwise-
decisions of this court when even in appeal that point was taken.
Otherwise, my lord, the father of the petitioner, he already died, my lord.
Sympathies
those
are with
things-
you. Sympathies are with you.
Those things, my lord,
The
how,
complete sympathy is with you. If I had jurisdiction, I would have allowed it. Compassionate appointment, I would not have given you. But that termination is clearly perverse.
yes, my lord.
Termination is perverse. But how can I entertain you?
Lordship has power under 226, my
I
lord.
don't have power.
There is no
It
bar.
is already laid down. Chandra Kumar, 3Q and 14, section 14 of the Administrative Tribunals Act, read with the Elson decision in Elson.
My lord, lordship may run 2 days time. I'll find anything, my lord, if I found something, so that lordship can take.
This court had query Mr. S. Dr. Learned counsel for the petitioner as to the maintainability of the present petition. In view of the fact that the father of the petition is an employee of the railways and the matter and the issue involved in the present petition is to be agitated at the first instance before the Central Administrative Tribunal. Mr. Datta has submitted that the matter be taken up on Monday. So. Monday date to be. I accepted registry to discuss matter again on Monday.
22nd.
For further hearing. Right.
High level.
May please, the lordship. My lord, here in this case, my lord, with petitioner,
Mr. Sigdar,
My-
just a moment. Yes, Mr. Chakraborty, what is your stand?
Lordship, we have not filed the affidavit in
Okay.
opposition. in
What
this
is
case,
your
Lordship.
stand?
We have rotated a plot of land, but it's not the criteria for.
We are interfering with your appointment because there is nothing here. You have not disputed the position. You took time in 2024 to file an affidavit. Where?
we have
Where
also
have you
not,
filed this?
we have also not received any copy.
We have not filed, we have not, there is no copy here. When did you file?
It was in 2024, Your Lordship.
It's not here.
I have to check it out. Just give me 1 week's time, Your Lordship.
What is your stand?
My stand is that they are claiming that we have donated a
No,
plot.
no,
of
what
land.
about your selection? I only want to know about your
I
selection.
have,
Where is that selection materials? Which is that selection you took part? Which is the year you were selected? What are those details? Mr. Sigdar can make any wild allegation he wants to, but you give me the materials
just give me the 1 week's time. I will check out.
today. Just show me that you were selected in pursuance to some selection process. And how can you file without even giving a copy to the petition?
This is the selected Lordship. I want to, for the Lordships.
Give me something.
This was.
Which is the advertisement against which you were selected?
Advertisement next year here in this petition also.
That advertisement.
Lordship.
Where is your name?
The number 7, Your Lordship. Serial number 7.
Okay. Mr. Sigdar,
My,
these issues we will not consider. You go before the director.
my,
He will take a plea because you have also, I think, raised a plea that she is not within the coverage area.
my,
He will take a plea on, he will take a call on
Right.
after hearing both of you.
my,
But Mr. Ahmed, go before the director.
Lordship.
Heard Mr. A.R. Sigdar, learned counsel for the petitions. Also heard Mr. A. Chakraborty, learned government advocate, appearing for the respond number 1, 2, 3, 4, 5. And Mr. I. Ahmed, learned counsel, appearing for the respond number 6. The petitioner in the present of the petition has presented a challenge to the selection and appointment of the respond number 6 as Anganwadi worker in 273 number Merua West Anganwadi Center. The petitioner in the petition has projected that she was initially engaged as you were engaged.
my lord,
Where
engaged,
is the order?
my lord, my lord, peace.
Engaged
3.
as an
Letter
Anganwadi
3,
worker temporarily for 3 months, subject to approval of the appropriate authority, wide a communication dated 2/11/2007 issued by the Child Development Project Officer, Silchar ICDS Project Rural over the top. It is projected that the petitioner. It is further projected that the said post against which the petitioner was engaged on temporary basis was put up for recruitment, filed a notification dated 31/8/2007. The petitioner contends to have submitted her candidature against the said post. However, the respondent authorities, however, it is projected that the respondent authorities, without taking the said process involved, without taking the process of recruitment to its logical recruitment initiated by the notification dated 31/8/2007 to its logical conclusion, had proceeded to appoint the respondent number six against the post, the respondent number 6 as Anganwadi worker in 243 number of what is it, so and so. Where have you taken the plea that she is not belong to that village?
My lord, my plea is, my lord, paragraph 8 and 9, my lord, without publishing the select list, he was.
That you forget. Where is that list? No plea.
My lord, I am a better candidate, I have that I have stated, my lord.
sir.
Paragraph 13. 12 and 13. I am a local candidate, she is not local, and
Where is
I am a
that?
better candidate.
It was further projected that the respondent number 6 did not reside within the coverage area of the Anganwadi center and or in the village wherein the Anganwadi center is so situated. Also, accordingly being aggrieved, the petitioner had instituted the present written. Mr. A.R. Sigdar, learned counsel for the petitioner, has submitted that there was no transparency maintained in the selection and appointment of the respondent number 6. He submits that the respondent number 6, being an outsider, being a resident outside the coverage area of the Anganwadi center and or the village wherein the Anganwadi center is so located, she was not a eligible candidate to submit her application in pursuance to the notification dated 31/8/2007.
My lord, one thing, my lord, my father also donated land to the center.
Mr. According to Mr. Sigdar further submits that the notification dated 31/8/2007 was not proceeded with by the respondent authorities, and no select list came to be published prior to the engagement of the petitioner against as Anganwadi worker in the said Anganwadi center. Accordingly, he submits that the appointment of the respondent number 6 being dehors the procedure mandated for the purpose, the same would mandate an interference. Mr. Sigdar has further submitted that the father of the petitioner, having donated the land wherein the said Anganwadi center is presently located, a right had accrued to the petitioner for having her case considered for engagement as Anganwadi worker in the said Anganwadi center. Mr. A. Chakraborty, learned counsel for the government advocate, submits that in absence of any instructions being received by him in the matter, he is not in a position to make his submissions. Mr. I. Ahmed, next up, learned counsel for the respondent number 6, the outset had submitted that affidavit on behalf of the respondent represented by him was filed in the year 2024. However, this said affidavit is not found to be on records, and Mr. Sigdar had also submitted that a copy thereof was not furnished to him. Mr. Ahmed, by producing the engagement order of the petitioner dated 4/3/2016, has submitted that the petitioner in terms of the said engagement, which was on the basis of the merit list published by the selection committee in pursuance to the selection committee in the selection held in pursuance to the notification dated 31/8/2007. He has also furnished a copy of the select list. However, the said documents have not been brought on. Also, Mr. Ahmed accordingly submits that the engagement of the petitioner as an Anganwadi worker in the said Anganwadi work center being in pursuance to her selection for the same, the same would not mandate any interference. I've heard the learned counsel and also perused the materials available on. The claim of the petitioner in the present petition is that the respondent number 6 is not eligible to forward her candidature to apply in pursuance to the notification dated 31/8/2007 for engagement as Anganwadi worker in the said Anganwadi center, or as she is contented to be not a resident within the coverage area of the Anganwadi center and or the resident of the village wherein they said Anganwadi center is so located. The petitioner further claims that the selection, the process of recruitment as initiated while the notification dated 31/8/2007 was not taken to its logical conclusion. Also, accordingly, it is projected that the petitioner projects that the selection and appointment of the petition of the respondent number 6 is dehors the procedure mandate. On the contrary, the learned counsel for the Mr. I. Ahmed, learned counsel for the respondent number 6, has submitted that in terms of the selection held in pursuance to the notification dated 31/8/2007, the petitioner was placed at serial number 1 in the selection, in the merit list prepared for the purpose. And it is on account, and it is on the basis of the merit position obtained by her that the respondent number 6 came to be appointed as Anganwadi worker in the said Anganwadi center, appointed, not engaged, said Anganwadi center, wide the communication dated 4/2000. So, in absence of any material available on record demonstrating the manner in which the selection was held in pursuance to the advertisement dated, pursuance to the notification dated 31/8/2007, and the contradictory positions taken by the petitioner and the respondent number 6 with regard to the selection process initiated after issuance of the notification dated 31/8/2007, this court is of the considered view that the said disputed position coming on record would not be permissible to be resolved by this court basing on the affidavits filed by the parties. Also, at this stage, it is to be noted that although the counsel for the respondent number 6 had submitted that an affidavit was filed by him in the matter on behalf of the respondent number 6, the said affidavit is not found on record, and Mr. Sigdar had also submitted that a copy of copy thereof was not also furnished to him. Also, accordingly, in view of the above position emanating in the matter, this court at this stage would not interfere with the appointment effected in respect of engagement effected in respect of the respondent number 6. The petitioner is directed to submit a representation before the director of what is that, Women and Child?
Women and Child Development.
Women and Child Development Assam, taking a claim, STAKING, claim for being engaged as a Anganwadi worker against the Anganwadi, against a number, like it be 243 number, so and so. The petitioner in the said representation shall urge all grounds that have been urged in the present petition, and the petitioner shall also be at liberty to urge further grounds that may be available for her to so urge. The director, social, women and child development,
Women and child.
on receipt of the said representation, shall schedule a date of hearing and issue notices both to the petitioner, issue notices to the petitioner, comma, the respondent number 6, as well as the departmental authorities, district department, and the authorities of the ICDS center, wherein the Anganwadi 243 number so and so is so situated, is so operated. Thereafter, on hearing the parties to the proceeding, comma, the director shall pass a speaking order dealing with all the contentions raised by the petitioner in her representation, as well as contentions that would now be raised before the director by the respondent number 6 in the hearing. Also, on conclusion of the hearing, the director finds that the respondent number 6 appointment was not so affected by following the procedure mandated in this engagement, was not affected by following the procedure mandated in connection. He shall issue orders towards terminating such engagement of the petition of the respondent number 6. Also, and thereafter deal with the manner, and thereafter also deal the manner in which the posting, the engagement against the shall deal as to the manner in which the engagement as Anganwadi worker in the said Anganwadi center is to be so effective. So the said exercise shall be initiated and concluded by the Director of Social, Women and Social Child Development within Assam within a period of 3 months from the date of receipt of a representation, along with the certified copy of this order from the petitioner. With the above observations, the present petition stands disposed of.
My lord,
Are you continuing till date?
yes, my lord. Since 1999, 3 to as of now.
What do you want?
My lord, my service has to be, my lord, regularized.
Regularized. That is the only prayer.
Yes, my lord.
Left. But Mr.
Yes, yeah.
S.J. Ahmed Leonard,
S.A.
S.A.
my
Ahmed
lord.
Leonard Counsel for the petitioner. The petitioner in the present, petitioner by way of institute, also heard Ms. B. Leonard Senior Counsel appearing for the
BTC.
BTC.
We have filed our affidavit.
Also heard Ms. B. Leonard Senior Counsel, assisted by Ms. J. Soikia Leonard Counsel, representing the BTC authorities. Also heard Mr. P. Nair Leonard Additional Advocate General appearing
19 of them.
for the respondents number 1, 2, 1 and 2. B. 3, 4, BTC, the Standing Council BTC, 3, 4, 5 and 6. I'm dismissing it.
My lord, the vice appointment is, my lord.
There is a
as per-
latest decision of the Supreme Court, Sukendo Bachchaji,
My lord, that
prior
is, my
to
lord,
1493.
this is way back of, my lord, 2006, 10/4/2006, my lord.
It says-
Umadevi.
It says,
Prior to
no,
Umadevi,
no,
my
no,
lord.
it says 1493 prior regularization, post no regularization. 493.
My lord, my service, my appointment was, my lord, kindly,
98.
no, my lord, 1/2/1993.
Oh, 93. You said then
93.
1498.
No, my
That is
lord,
why I was dismissing it.
93.
Okay. Yes.
It is,
Lordship will file an affidavit, my lord, way
Ah.
back in 2008, it's on record.
But he says that he is continuing till date.
Lordship, there's an office memorandum, government of
Forget the
Assam.
office memorandum. It is in paper. It's in the file. Where have you implemented it? Poor man, you are making him clean the office premises daily and you don't pay him.
Lordship,
Merely saying, where is the order of terminating his services? Disengaging him.
we need to take instruction whether he is.
What
continuing
is this? 2015 matter?
16 matter.
16 matter? Sorry. We are
Lordship,
allowing
let
it.
me take instruction. This is
Who
an affidavit.
prevented you, Miss Bhuya, to take instruction? We didn't prevent you.
Oh, there's an affidavit, my
When there
lord.
is a plea taken that he is continuing till date, we'll ask you to verify that he is continuing. Full wages, regularization. These poor people should
My
not do
lord,
this.
I understand. I am with your lordship, but finance comes from the government of Assam.
Then, madam, that is, I appreciate that. Let me pass it out.
Lordship, I thought that your lordship is dismissing, but.
I thought it is
yes.
98. That is why I was dismissing.
Let me see the appointment letter once.
Appointment letter at page 13.
But finance comes from government of Assam, your lordship.
Mr. Nayak is always opening his purse for you. You take whatever you want, legally.
1st February 1990.
Why you are behaving in this manner, mighty state, against a sweeper? Huh? He is
Mighty
the most
Sitting
vital.
beside me, my lord.
He is the most vital cog in your. Nobody will be working
I
there.
understand. I was born as a poor man's advocate, your lordship, in this profession, my lord.
We know that. Ms. Bhuya, we know that.
SDP, in the office of the subdivisional welfare officer, Gosaigaon. Lordship, let them verify if he's continuing, then.
Full.
Then payment by them.
We are the least concerned with the division bench because Sukendu Bachaji came other day.
Yes, yes.
We will now make it in rem. You make your submissions.
That issue is before the division bench.
That issue cannot be before the citizens. You need judge, Supreme Court passing an order. I have nothing. I can't even question it. Para 76, I'll reject it.
We are raising that.
141, I'm rejecting.
That is why I'm paying off. Let the division. 25.
My opinion will also be there before the division bench. It will help adjudication.
And the blood test.
We can't help it. We can't help it. We can't. Where is the law that
16. 25. Decide.
Otherwise, I have no option.
heard Mr. S. J. Ahmed, Learned Counsel for the petition, also heard Ms. Soblikijana, as prayed for by Ms. B. Bhuya,
I'm not.
heard the Learned Counsel for the petitioner at some length. Ms. B. Bhuya, Learned Senior Counsel, submits that Mr. B. Bhuya, Learned Senior Counsel, and Mr. P. Nayak, Learned Additional Advocate General, submits that they be granted time till 15/7/2026 to complete, to receive instructions as to whether the petitioner is continuing in his services. Also, I accepted registry to list this matter again on 15/7/2026 for further hearing.
My lord, obliged,
Not leaving it, I'm just deferring it.
obliged.
Obliging.
18 to 2.
Yes, Mr.
91, 92, 94, I was appointed. Then I was promoted in 2013. That assured career progression scheme was provided to me in 14. It should have been effect from
How many petitioners are there?
my lord, their petitioners are my lord, 7. They were para 2. I have given the date of appointments.
Okay. Petition number 1 was appointed on
Petition number 1, my lord. Petitioner number 1 joined on 4/9/92.
4/9.
9/92. Petitioner number 2 joined on 5/9/92. Petitioner number 3 joined on 24/4/1995.
24/4,
1995.
1995.
Petition number 4 joined on 30/8/1997. Petition number 6, 11/12/1995.
Petition number 5.
5, my lord. That will be 5, my lord. I don't have that 5, my lord.
What is the name?
5 is 5 Urup Jyoti Hazarika. What I get, my lord, petition number 6 joined on 11/12/1991. And petition number 7 joined on 15/3/1994.
They joined as
Sub-register.
sub-register.
And they were promoted in, my lord,
Promoted. Petition number 1.
they were all promoted, my lord, in the year, page 17,
Give me the
27,
date. Give me the date.
27
number 1.
November 2013.
Petition number 1
Petition number 1,
is
I just see the name and yeah. Gautam Sharma in 27/11/2013.
Hmm.
Petitioner number 2, same date, my lord. Petition number 3. Petition number 3, my lord. Date I don't get, my lord. Petition number 3. Petition number 4, Taran Deori, he was Polita Bora. Deori is not there. But as regards.
These are the basic requirements. The dates.
My
You
lord.
are claiming MSCP.
My lord, correct.
If you can't give the dates, how can I make the calculation?
As regards, my lord, those persons who are, the documents are there as regards.
And others will say we don't have material, we are not considering.
My lord, those who are there can,
Okay,
because
now tell me.
I have no contract with them also and nothing. my
Okay,
lord.
now tell me.
As regards, my lord,
Petition number 4.
petition.
3 you don't have.
My lord, petition number 7 is that, my lord, he gets the promotion in, my lord, 29 January 2016.
So as per the MSCP scheme,
My lord, that is page 22.
it is 12 and
Page 22, your lordship will find. The serial number 4. The first financial upgradation under the ACP scheme shall be allowed after 10 years of regular service.
10 years, not 12 years.
Well,
10 years.
10 years.
10 years. So 1992, if you were appointed. So 2002, you complete 10 years.
Hello.
So if you complete 10 years on 2002, you will get the benefit from 1/1/2011. And from 1992, 24 years would be 2016. So in 2016, you will get your second financial upgradation. Now you have got one promotion.
One promotion. That is in 13.
One promotion. So you will get one upgradation. So you have not got any upgradation.
But we have got it, but the effect was given from 2014.
Where is that?
My lord, my lord, one document of what I find, that is your lordship will find at page 32.
Which are the petitioners here?
Here, my lord, your lordship will find number 6 is a petitioner.
No, give me the number.
It's really, my lord, if I can place it. Name of
Mr. Chaudhary, this will not do. You get me the complete breakup. Dates
and
the.
my lord, I will give a short list of dates. My lord.
We'll have it on Monday.
Monday. My lord.
On the prayer of Mr. P.K. Roy Chaudhary, Learned Senior Counsel, registry to list this matter again on Monday
Madam,
for further hearing.
madam, obvious.
We'll have it because without these details, I'll not be possible for me to. I tried to find out, there is nothing.
Yeah, people lordship, in the pertains to the application from grade.
You are a grade 4 employee.
Yes, my lord.
You want promotion to grade 3.
Yes, my lord.
Now, if it is a
Second time-
promotion to grade 3,
Yes,
which is the date you are claiming that promotion?
date of interview.
From which date you are claiming the promotion? Or if I give you the promotion today also, it will be satisfied.
Item number 18, my lord.
Hmm.
The petitioner, this is a second time petition, my lord.
Huh?
This is a second time litigation.
Oh,
Earlier, one of the junior to the petitioner, he was promoted to the grade 3 post.
okay. When was that date?
And in 2004, 16/11/2004, my lord.
So that is gone. We are not concerned with that.
Yes. Yeah.
And the second superstition occasion on
Second, thereafter the petitioner for non-compliance of the order, petitioner filed a contempt petition and that contempt petition was closed. It was seeking order that the vaccinator of the post of vaccinator was abolished and the surveillance worker post was created, which is directly recruited. But thing is not that after that is on 2012 order, my lord. And on 2013, another order was issued by the director of from the Joint Director Health Service, that is on 5/1/2013, my lord.
Hmm.
They have stated that 9 posts of vaccinator was still vacant.
but vaccinator is a direct recruitment post.
No, surveillance worker is a
What
direct,
is the qualification for vaccinator?
minimum HSLC. And petitioner is a
Show
HSLC
me that it's a promotional post.
promotional post.
You will not find that vaccinator there. That's the district ministerial establishment rules. You will not find that vaccinator post there.
Yes, a district minister.
It's there. Vaccinator post is there.
No, only whole health department, the grade 4 post to the vaccinator.
Vaccinator is a specialized post.
Yes, my lord.
You are a grade 4 employee.
Yes, grade 4.
You are a dresser.
Yes, sir.
You are not a surveillance worker.
No, I am not
Surveillance worker will go in that line.
grade 3 post, my lord.
It will go in that line.
That lab.
You can't go in that line.
Yes,
You will have to go as a peon.
peon.
You are a peon, equivalent, dresser, grade 4. You will go as an LDA
Yes.
or SA, something like that.
Now, NMA post is there, non-medical assistant post is there, which is a grade 3 post. That is lying vacant, my lord.
Non-medical,
Assistant,
what is the qualification?
SSLC.
Where do I get that?
That is non-medical. I have filed an affidavit in reply.
What is the qualification? What is the procedure for recruitment?
I have annexed in my reply annexure to page 50.
Page 50.
Page 50, there is a post vacancy position is there. 4 post is was vacant. Still vacant.
Where?
In my affidavit in reply.
Hmm.
Ah, no, yeah,
Para?
Para. Para. Para 4, but
Hmm.
I am reading from page 44, my lord.
Hmm.
As the respondent number 4 stated in the
Which
affidavit.
case you are taking up?
44, my lord.
No. Which case? 18 or 19?
That is WPC 7194 2017, my lord. WP 18.
19. 7194 is 19. Page?
Page 44. Page 44, my lord, where it was stated that
Para?
para 4, last part, my lord. I am reading from 44. I am reading as the respondent number 4 stated in his affidavit that having vacant section posts like vaccinator, surveillance worker, and NMA, non-medical attendant, lying under the establishment of the Joint Director Health Service, Udalguri, and abolition of vaccinator posts by Government of Assam's so and so 4/8/2009. Your deponent denied the state that the post of vaccination is still lying vacant and thereby the Director of Health Service, which is the Koprada Joint Director, and the total vacant post of vaccination is
Now show me the manner of recruitment to NMA. How is NMA to be done?
recently, my lord, they have advertised the post of NMA where it was stated that
No, where do I get it that it is a not a direct recruitment post, but a promotional post also?
Yes.
These are all specialized posts. Only LDA is there. And LDA 10% you will get.
yes,
But for that you will have to have graduation. You don't have graduation.
graduation up to graduation post.
No, for recruitment to LDA, in terms of the rules holding the field, you must be a graduate. You're not a graduate.
Yes, my
So
lord.
how do you get it?
The senior merit comes seniority.
But your minimum qualification is graduation.
SSLC.
No.
Yes.
Oh, some services. What is your prayer?
There. There to promote to the
To grade 3 post.
great trip.
You come to the district level, ministerial district level 191.
My prayer is to promote him under the district and also name the API. And his name also appeared in the merit list in 2011.
That is gone.
That is
That
gone.
you cannot
Just
now.
my lord, but after having a high court order,
By selection on basis of seniority come merit
merit,
from grade 4 staff of the district establishment concerned who have passed the degree examination in any discipline.
who has passed the higher secondary.
No, that is amended.
Indeed.
That is gone. Amended by declaration at least 7 years. This was amended in 2015.
2015, the petitioner has already
We can't.
7 years, no. He has already.
Maybe, but the date of consideration, you will have to have that degree qualification.
Recently, my lord, the petitioner has filed a writ petition in 2017, my lord.
17, the qualification was already amended to degree.
That is true. But he's the person who is already junior. He has already been promoted.
You have
my
not,
lord.
have you made him a party?
Earlier in writ petition, we made him.
Earlier, what has happened is gone. Now, in this writ petition, why should I proceed to interfere with his appointment without hearing him?
In respect of the writ petition number 19, my lord, one of the petitioner who was is a graduate, my lord.
Which one?
Second one, Maneswar Brahma. And his case was also considered by the respondent by the respondent authority. By they have stated in their affidavit. And
He is already promoted.
And till date, he is not promoted, my lord.
He'll be promoted. That decision is there.
This is there.
We'll say that.
Hmm.
Once that
But-
decision is there, that has to be implemented.
But
Others will not be eligible.
in the petitioner number 1 in that petition, he is HSL, higher secondary part.
2 is Mansma Baro.
Mansuram Boro.
So he is true. They will promote him when they said before the High Court by way of filing affidavit
Yes.
that he is found suitable by the DPC. How can they not promote him?
The petitioner claim is rejected in their affidavit that a lack of experience, my lord. Due to lack of experience, that no experience certificate was found. After
That
working,
we will not take into account. We'll only take into account that you don't have the educational qualification.
but the person was rejected after after doing so many times, years,
Can't help it.
having
help
rejected
it.
only on the
That is law.
lack of
That
experience.
is law. You make a challenge to the provision.
Yes, my lord.
Anything more?
Jonas Dermari also found work experience certificate but not qualified. And not,
Yes. One whom you have found qualified, find him, promote him.
No, sure.
Others, we are not forcing. Anything? You can promote all the 3. Oh, you are the main man. Main person, sorry, person. You direct, they will promote. There is no advertisement.
yes, my lord, advertisement issued, my lord.
When? Where is the advertisement?
Came to my knowledge, but advertisement later on, after filing this case, this
Advertisement for which post?
NMA post, vaccinator,
So that those are all direct recruitment.
direct recruitment. That is why I'm-
Lordship, I've got it was in my files of 2020. Lordship, may kindly have a look. And I should fairly submit on the last occasion, this honorable court directed us to, what you know, she should have submitted to place it before the court as regards vacancy position, my lord. Is there any vacancy?
vacancy position is there, my lord.
Those posts are direct recruitment.
Right.
He will be entitled to be promoted as LDA or similar post in the normal sector by applying the provisions of the Assam District Ministerial Service. Now, for applying that, she should be a graduate. He's not a graduate. You want to consider his case for promotion? I can pass a direction.
No, the person who has been promoted, Lordship, it's in our affidavit, we have taken this step.
That we will.
Yes, others, since he doesn't have the qualification.
Okay.
I'll leave it to Lordships.
But Mr. A. Bhattaji, learned counsel for the petition. A. Buzogua, learned counsel for the petition. Also heard Miss S. B. Bria, no, Miss S. Sharma, learned standing counsel, Health and Family Welfare Department, appearing for the respond number 1. Also heard Miss S. Bria, learned senior counsel, assisted by Miss R. Saloy, learned standing counsel, Bodoland Territorial Council, appearing for the respond number 2, 3, and 4, 3, 4, and 5. So, the petitioners in the above noted 2 petitions have, by way of instituting the set of the petitions, prayed for a direction upon the respondent authorities for promotion of the upgradation of the posts has prayed for their promotion to the cadre to the grade 3 posts by reckoning the services rendered by them since
Fine.
1994, 1998 and 1990 respectively. Uta writ petition ekkalage. The issues involved in the above noted writ petitions being similar, with the consent of the learned counsel for the parties, the same were taken up for consideration analogously and is being disposed of by this present order. The petitioners in the above noted writ petitions have projected that the petitioner number 1 in WPC number 703/2018 was appointed as a grade 4 bracket chowkidar by an order dated 11/3/1994 issued by the Joint Director of Health Services, Thorom, Mongoldo. Similarly, the petitioner number 2 temporarily as grade 4 as the grade 4 chowkidar. The services of the petitioner number 1 was in WPC number so and so was thereafter regularized by an order dated 17/6/1994. Also, the petitioner number 2 in WPC number so and so was initially appointed as a sweeper on temporary basis for 90 days by an order dated 26/10/2008. Also, the services of the petition number 2 in WPC number so and so was thereafter regularized by an order dated 22/2000 and 22/2/1999, and it is projected that the petitioners in WPC number so and so were continuing in their respective services thereafter. Also, the petitioner in WPC number 7194 was initially appointed as a grade 4 employee on temporary basis via an order dated 18/4/1990. The services of the said of the petitioner was thereafter confirmed via an order dated 7/12/1999, and he is thereafter continuing in his services. Also, the petitioner in WPC number 5232 petitioner in the WPC numbers issued today 7194/2017 had initially approached this court by way of instant a writ petition being WPC number 5232/2008 being agreed by his non-promotion. A coordinate bench of this court wide order dated 15/6/2011 had disposed of the said writ petition, requiring the PTC authorities to pass appropriate orders upon considering the grievance of the petitioner. It was further provided that if the petitioner is superseded,
Lordship, may I leave for another quote?
superseded in the matter of promotion, his grievance may be redressed by considering this case applying the principle of apostrophe next below rule. Also, the petitioners in the above noted with petitions not being further considered for promotion to the next higher grades, comma, have instituted the present writ petition. In the above noted writ petitions, the petitioners have claimed for promotion to the posts of vaccinator, of a surveillance worker, comma, vaccinator, comma, non-medical assistant. The respondents have contended that the said claim of the petitioners would not mandate a consideration inasmuch as the said posts are all direct recruitment posts covered by the provisions of the rules of 26 2006, huh? By the by a set of rules framed by a set of service orders known as the Assam Vector Borne Disease Control Program Workers Service Orders 2006. Also, this court has examined the said issue and has found that the post of surveillance worker, comma, vaccinator, comma, non-medical assistant are all technical posts and the same are to be so filled up under the service orders holding the field by way of direct recruitment. Accordingly, the claim of the petitioners against the said post would not mandate a consideration. So, the petitioners being found to have been holding grade 4 posts, comma, the promotion of the petitioners would be now governed by the provisions of the Assam Ministerial District Establishment Service Rules 1967. Also, Rule 6 of the said rules provides for the manner of recruitment to the post of junior assistants in district level establishments. A perusal of Rule 6 would go to reveal, Rule 6B would go to reveal that grade 4 staff who have the degree qualification and have rendered at least 7 years of continuous service in the district establishment on the first day of the year in which the selection is made is eligible for being considered for promotion against the post of junior assistant to the extent of 10% of the cadre strength. Also, the respondent authorities. Also, at this stage, it is to be noted that the petitioner number 1 in WPC number 703/2018 and the petitioner in WPC number 7194/2017 do not have the degree qualification. The petitioner number 2 in WPC number 703/2018 has the degree qualification. The respondent authorities, by way of filing an affidavit in the matter, have placed on record that the district that the departmental promotion committee had considered the cases of the petitioners in the above noted 2 petitions in terms for promotion in terms of the provisions of Rule 6 bracketed B of the said rules of 1967. On such consideration, the petition number 1 in WPC number 703/2018 and WPC number and petitioner in WPC number 7194/2017 were found to be not eligible for being promoted on account of the fact that they did not possess the degree qualification. On a consideration of the case of the petitioner number 2 in WPC number 703/2018, it was found the DPC had found the said petitioner to be eligible and suitable for promotion to the post of to any grade 3 post. So the above consideration as made by the Departmental Promotion Committee in the considered view of this court is in connivance with the provisions of Rule 6B of the Service Rules of 1967 and the finding as arrived at by the Departmental Promotion of the petitioner number 1 in WPC number 703/2018 and the petitioner in WPC number 7194/2018 to be not eligible for such promotion in the considered view of this court is not erroneous. Accordingly, the claims made by the said petitioners in the present petition would not mandate an acceptance. With regard to the petitioner number 2 in WPC number 703/2018, the said petitioner is found to have completed more than 7 years of service as a grade 4 employee and also possesses a degree qualification, and accordingly, he is entitled to be considered for promotion to the grade 3 post. The Departmental Promotion Committee, having considered the case of the petitioner number 2 in WPC number so and so 703/2018 and found him suitable, the respondent authorities are directed to promote the petitioner against an available vacant post within a period of 1 month from the date of receipt of a certified copy of this order. With the above observations and directions, the present writ petitions, the above noted writ petition stands disposed of. Mr. Chaudhary, what are you waiting for? Mr. Nair, you are waiting for number 1. First item.
6 and the next one, 20.
20.
20. And 6 is, but Mr. Gogoi is not here, madam.
Mr.
He was
6. 20. Okay, 20. Chaudhary, your number is?
21, man.
Okay, next one. Oh, 21 I can't take up. That junior that degree
Yes.
from JNR, PWD,
the
Dharmeshwar
issue-
Decca.
Yes, my lord. The issue is different here.
No, I appeared for all them.
Oh, I am sorry.
21 to Likha. List before any other bench without me. I appeared.
My lord, I'm sorry, I didn't notice that.
My orders are not there, but the earlier division bench orders, my lord Justice, first is by Justice Chaudhary, then by Justice Sridhar Rao and PK Swike, sir. Division bench, I appeared along with Justice, subsequently Justice Monojit.
It will come after the vacation.
After the vacation. It will come after the vacation, not before by me. You need not wait. Any other matter?
No, my. Of course, one of these, item number 4, your worship was to deliver order. That your worship has said it will be taken up later.
Provided, I'll try to pass it today or I'll reserve it, pass it after the vacations.
Obliged.
May I please your lordship, kindly pass over him.
If need be, we will come to you. But let Mr. Nair get over. Yes, Mr. Nair.
I know the recruitment process was of 2012, my lord. The contention of the respondents, my lord, in their affidavit,
Hmm.
because earlier it was filed before the Punjab and Haryana High Court. Contention was that there was an SOP of the Ministry of Home Affairs,
Opus.
four posts.
Hmm.
What I would be on, my lord, is that another of the persons who was aggrieved, my lord, he had also approached the Meghalaya High Court. In my additional affidavit, that has been brought on record. If my lord takes up the additional affidavit starting from page
106.
80.
Page 106.
Yes, my lord.
Okay, let us see.
My lord. That's it. No. Page 87, if my lord takes up for a moment, in the additional affidavit.
Meghalaya High Court, my Lord
Yes.
Justice, thank you's order.
Yes, my lord. Yes, my lord. There, if my lord comes to page 95, that is para 13, the
Para?
second last page, but there might be a mistake in the numbering. The
Okay,
second
no,
last
please,
page.
just give me the para.
Para 13, my lord. The second last page. There's a table, my lord. Para 13, lordship finds the table.
Hmm.
There, lordship will see serial number A and B. The names of the persons selected as per the records
Hmm.
are mentioned. Serial number A, ID number 1229 is Amit Kharab. Then serial number B, ID number 519 is Naveen. The rest of the persons, they are there. Now, if my lord takes up page 87, the folded page, my lord, of this affidavit.
These people are your petitioners are
No,
not
no, my lord.
party
These are not,
respondents, sir.
no,
Not named there.
they are not named.
Then
These persons, the select list as per them, the select list which they have furnished to us, my lord.
two persons were after review medical.
Yes.
Further 2 persons or
One person and one was compassionate.
okay. So 1, 2, 3, 4, 5 persons appointed.
My lord.
6
my
persons appointed.
My lord.
Then
My lord, here, my lord may come to page 87.
87
87, the folded page, my lord.
of the writ petition.
No, my lord, of the, my lord,
Additional
of the additional affidavit.
Yes.
The folded page of this affidavit.
Yes.
My lord will see the list of selected candidates.
Hmm.
The names are Deepak Kharab, Sachin Nandal, Ajit Singh, and Deepak.
Hmm.
And my lord, the list of
You
the
are
other.
all general.
No, my lord, not all general. One general, two OBC.
1 general, 2 OBC.
My lord, petitioner 1 is general, 2 and 3 are OBC.
3 petitioners.
3 petitioners, my lord.
1 is general.
1 is general, my lord.
2 and 3
Are
OBC.
OBC.
What is the cutoff marks for OBC?
My lord,
It is 63.
63, my lord.
And for general?
General is 65.
65.
Right.
How much did you all get? Where are you here? In
My lord,
the...
down below in the list of candidates low in merit. Here, my lord, lordship will also see, my lord, serial number 4, Kishan Kumar. He is there in low in merit, but he has been appointed on compassionate grounds. Fine. Then I am, my lord, at serial number 2, Sandeep. I got 54. Then, my lord, next page, serial number 6 and 7, OBC. We got 56 and 53.
This is petition number 2 and 3.
2 and 3, my lord.
Anil Kumar is 2.
Anil Kumar is 3. Naveen is 2.
So you got marks less than the cutoff marks.
My lord.
Then?
My lord, that is there. My lord, what I am on, my lord, is that in the records which they produced before the Meghalaya High Court, these 2 persons who are not there in the list, they are shown as appointed out of the same very recruitment.
Oh, that the Meghalaya High Court has considered and found that it's fine.
My lord,
We will not go into that.
my lord, I am not on appeal from the Meghalaya High Court, my lord. What I would be on, my lord, is that
that is too vague a plea. Once there this document maybe you have brought, but that this may be the correct position. But even if we go by this position,
my lord,
you are not coming in.
Admittedly, we are below.
Okay,
What
that is
I
the
am
end of the matter. But Mr. P.D. Nair, Learned Counsel for anything more? Anything more? But Mr. P.D. Nair, Learned Counsel for the petition. Learned Senior Counsel appearing for the petition by Ms.
Wapangla,
Learned Counsel for the petitioner. Also heard Miss
M. Burman on
M.
behalf of
Burman,
Mrs.
learned
Legan.
counsel appearing for the appearing on behalf of Miss A. Gayan, learned CGC. The challenge in the present repetition is to the impugned final select list prepared for recruitment against the post of Havildar clerk in the Assam Rifles in pursuance to an advertisement published in the employment dues on published in the news dailies on 5/10/2012. Also, the petitioners project that they on petitioners further assail the reservation of vacancies for the state of Haryana. State of Haryana? Haryana. So, as projected in the petition, the petitioners, in pursuance to the advertisement dated pursuant to an advertisement dated 5/10/2012, had submitted their respective applications for recruitment against the post of Havildar clerk. In terms of the advertisement, 328 posts were so advertised. So, the petitioners had cleared all the stages of the selection process, and the petitioner number 1 in the selection had secured 54 marks, and he belonged to the general community, while the petitioners number 2 and 3 had secured 56 and 53 marks respectively, and they belong to the OBC category. So, the petitioners not having been brought within the merit mandate, having not been included in the merit list for appointment against the advertised posts, the petitioners have instituted the present writ petition. Mr. P.D. Nair, learned counsel for the petitioner, submits that in the advertisement, it was mentioned that 328 posts of Havildar clerk were put up for recruitment. He submits that a proportionate distribution of the said post is mandated to be made with regard to all the states, reservation for which is provided in the recruitment process. He submits that for the state of Haryana, arbitrarily only 4 posts came to be reserved, and on account of the same, the petitioners were not recruited. Mr. Nair, thereafter, by referring to the final merit list of candidates for recruitment of Havildar clerk and warrant officer against the quota reserved for the state of Haryana, has submitted that the names of the person who have been declared therein to have been selected on merit, declared to have been selected on merit, is not the same as recorded by the Meghalaya High Court in its order dated 17/9/2020 in WPC number 177 of 2018, pertaining to the very same selection process as involved in the present petition, as well as the recruitment against the post mandated for the post reserved for the state of Haryana. Also, he submits that the variation in the names of the selected candidates leads to an apprehension of manipulation being made by the authorities in the select list. Accordingly, he submits that the said select list would mandate an interference from this court. Ms. A. Gain, Learned Counsel for Learned CGC, Ms. M. Burman, Learned Counsel appearing on behalf of Ms. A. Gain, by referring to the affidavit filed in the matter, has submitted that the distribution of vacancies against various, allocation of vacancies against various states is so made on the basis of the policy of the Ministry of Home
Affairs.
Ministry of Home Affairs. She submits that applying the said policy, 4 posts came to be allotted to the state of Haryana. The said allotment being in terms of the policy holding the field, she submits that it is not open for the petitioner to assail the same. So, the Learned Counsel, Ms. Burman, further submits that in pursuance to the selection made, a select list was published against Ms. Gain. Select list was published by also factoring in the various categories involved, and also such list was so published with regard to the allotment made in respect of the states involved. She submits that the petitioner had applied for recruitment against the post of Havildar clerk against the post allotted for the state of Haryana. Ms. Gain further submits that the petitioner not having come within the merit position, petitioners having not come within the merit position, they were not extended with an appointment in the matter. Now, Ms. Gain, Mr. Nair submits that the names in the final select list and the names in the order quoted by the select list quoted by the Meghalaya High Court, there is a difference.
Yes, my lord.
Why?
There is a reason, my lord, because of review medical board, my lord. There is review medical board is in page.
Deepak Kharab becomes Amit Kharab. Sachin Nandal becomes
My lord,
Naveen.
stated in my.
Ojit Singh becomes Ojit Singh. Deepak is okay. Praveen Kumar steps in.
My lord,
Now you have 5, 6 people.
The review medical board, Praveen Kumar, that is correctly recorded.
But what
Yes.
about the top portion?
Yes, ma'am. These 2 persons,
Yes.
page 95 to 7.
There might be some error here. Who was the counsel there? Not,
Where, my lord?
Mr. Paul was for,
I thought the same counsel was there.
no one.
There was that we have stated in our affidavit also, my lord, the
Ah.
reason behind that, my lord. And
Submits that.
yes, my lord. My lord, petitioner was not selected because of the lower in merit, my lord. That is one of the part, my lord. Then
Also, submits that although even if the difference in name as occasioning in the final merit list brought on record, as well as the names of the selected candidates are recorded in the order passed by the Meghalaya High Court is considered, it would be found that the selected candidates had secured more marks than the petitioners in the present proceedings, and accordingly, on the said count also, the petitioners cannot claim for an appointment against the vacancies, against any of the advertised vacancies. Also, I've heard the learned counsel for the parties and peruse the materials available in record. Also, in terms of the procedure for selection as laid out in the advertisement dated so and so, comma, the final select list of a candidate candidate qualifying in the various segments of the selection process would be prepared basing on the aggregate marks obtained by such candidate in the reserved in the reserved in the written examination. The advertisement further provides that where is that stipulation in the advertisement? That the distribution of vacancies amongst various states would be based on the policy issued by the Ministry of Home Affairs in this connection. The respondents in their affidavit have highlighted that basing on the set policy, by applying the set policy to the number of vacancies put up for recruitment, more particularly against the post of Havildar clerk, comma, 4 posts came to be allotted to the state of Haryana. So, the petitioners in the present petition have raised a grievance with regard to the low allotment of posts to the state of Haryana. However, while projecting the said grievance, comma, the petitioners have not brought on record any material to demonstrate that the procedure adopted by the respondent authorities for allotment of posts of Havildar clerk put up for recruitment to the state of Haryana was in violation of the policy laid down in this connection by the Ministry of Home Affairs.
We have stated in page number 11 of my affidavit in opposition.
Praveen Kumar.
Yes, my lord. Praveen Kumar and Krishna Kumar, my lord. We have stated, my lord.
Okay. So, this court finds that the allotment of the vacancies to a particular state in the recruitment process initiated by the advertisement dated so and so is a prerogative of the respondents, and in absence of cogent materials being brought on record by the petitioner demonstrating an illegality or irregularity in such allotment made, comma, it is not for this court to proceed to interfere with such allotments made in the selection process or allotment of vacancies made in the recruitment process to various states. Accordingly, this court would proceed to consider the issue raised in the present petition by holding that the 4 posts of what do you call that?
Assam Rifles.
Havildar clerk allotted to the state of Haryana was so allotted in terms of the policy in this connection of the Ministry of Home Affairs. So, having drawn the said conclusion, this court finds that the cutoff marks for the general community candidate in the selection process was 65 for general community candidates and 63 for the OBC community candidates. Also, insofar as the vacancies, posts allotted to the state, post of Havildar clerk allotted to the state of Haryana is concerned, the petitioners in the present selection process have secured 54,
My lord,
56 and 63 marks, 53 marks respectively. Also, accordingly, the petitioners are found to have secured marks lower than the cutoff marks obtaining in the selection process pertaining to the vacancies available for recruitment against the state of Haryana. Also, although a variance is found with regard to the names of the selected candidates in the final merit list of candidates as brought on record by the petitioner, and the list of selected candidates as recorded in the order dated 17/9/2020, passed by the High Court of Meghalaya, in WPC number 177/2018, pertaining to an issue raised before it relating to the same very selection process, this court finds that the said issue need not detain this court inasmuch as in both the final merit list as relied upon by the petitioner and the list of selected candidates as set out in the order dated so-and-so by the High Court of Meghalaya, the candidates so selected have scored more marks than the petitioners herein. Further, it is to be noted that the marks as reflected against the names of the petitioner in the final merit list as relied upon by the petitioner is not disputed. Also, in view of the above discussion, this court finds that the claim made by the petitioner for setting aside the impugned selection and appointment made of candidates against the post of Havildar clerk allotted to the state of Haryana, which were put up for recruitment while the advertisement dated 5/10/2012 would not mandate an acceptance. Accordingly, devoid of any merit, dismissed.
My lord, just one thing, my lord. The absence of cogent materials, my lord, in our writ petition, we had brought on record the affidavit filed by the union in the Punjab and Haryana High Court, page 41, my lord. There they refer to the SOP or the policy of the Ministry of Home Affairs of 2015. That is what we had protected, my lord. Page 41, my lord.
No, they have not gone into, but they have given a calculation.
Yes, they have given
that because of this reasons, the reduction and
yes, ma'am.
You want, I'll incorporate that also.
For satisfaction.
লিখি দিয়া এই কোজেন মেটেরিয়ালস আছে নহয় এটা দাগ দি কিনে মুক্তি দিবি তাত খালি এটা লিখি দিবি elaborate further. I'll do that.
My lord, but in the affidavit filed by the respondents, my lord, they have said that they follow the policy of 2012. That, of course, is not my submission, my lord. They follow the policy of 2012. And
so policy 4 posts, 6 posts, what is your headache?
My lord.
You give me the calculation that this should be so much.
No, I'm not on that.
Okay, fine.
There was
that much I'll elaborate. Don't mind.
There is an interim order that may be.
Interim order passed earlier, stands vacated.
Deeply obliged.
Mastam.
Oh, the TCP.
Sir, I have gone through the records, my lord. I have gone through the records, my lord. 4 to 5 records are there. I have not found any, my lord, marks given to the other candidates. Only found the selected candidates marks. No other marks has been given, available in these, my lord, records.
We will set aside everything. We will not give him, but we will set aside everything.
My lord, the order passed by the director. The scrutiny they have got.
We will now set aside everything now. We will not remand it. We will set aside because of this thing. They are party respondents.
My lord, the 3 persons there.
3 appointments. If this is the nature of selection held, why should we give
the private
seal of approval?
My lord, your lordship will find the written test, they did not succeed. Their names were not there. Subsequently, the writ petition was filed, my lord. One correction.
But the learned counsel for the parties at some length raised it to list this matter again on Equis 21/7/2026 for further hearing. You get through the records nicely. I was against Mr. Hazarika. Now, if that is the submission, then we will have to
see. It is true, my lord. I have gone through all the files, my lord.
All dirty further, wear a gloves, little bit of sanitizer,
all dirty,
and not like this.
That is the, but all dirty files. gap, my lord, that gap. That gap, my lord, that I'm on that part, that admissible, that part, my lords. My lords. 84, I had no knowledge, my lords. I didn't know knowledge. In fact, that, if lordship goes to that also, no, my lord, if then in fact, my lords, in fact, if lordship goes to that point also, lordship will see that all total they were given 9 months. 9 months to conclude. My lords will see, kindly come to the original order. Yes. I have not assailed, my lord. I'm not assailing, my lord. I have, my lords. And that I understand. I'm not suppression, my lords, but they are not arguing that point. I know that. Because, my lords, I'm, my lords, then I have to file a rejoinder. Then in that case, I'm on a different count, my lords. My prayer is something different. When I was reinstated, no, my lords, kindly come to page 32. I'm on 32, page 32. 32. Before that, my lords will have to go to page 23, my lords. There's a direction. I was reinstated, my lords. Page 28 is the operative. The very order says it has two faces, my lords. One says consequential benefits. Then they have a liberty. Then while reinstating me, my lords, they deduct my 50%, invoking FR 54. Whereas FR 54 A3, I'm covered by A3. I am entitled to all benefits, my lords, till the date of next charge sheet or punishment, whatever, my lords. And that punishment is also deduction of one increment without cumulative effect. That is my case, my lord. I am on that, my lords.
Five.
They have invoked 54, FR 54. My lords. Exactly, my lord. Now, lordship will kindly come to my lord, no, my lord. That's what I'm trying to impress upon my lords. I was reinstated, my lords. There was no provision, or there was nothing on my lords. My lords. Yes, my lords. 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 Unless there's no order. Exactly, my lords. I was. Obligations.
I have that record I have to place whether cross-examination was allowed or not. 30 and yes, he's sitting. He will not talk to me now.
Yes, my lord.
Only one point, Lordship, I'd like to place.
माझा तो बेलेग केस नाही ना.
Kindly see this. These are kept in C files also, that's why the. Yes. The photographs. Receipts are there. Yes.
Engraves.
I asked for the original copy, he said that is not never. Get them there. His signature is not there. Everything is kept, all are recorded in the clip. Yes. Like in our criminal trials. From that stage, Lordship may direct for de novo inquiry also. And now I'm making Lordship. From that stage, it can be.
Affidavit of- what is it? Kumar affidavit of- Not affidavit of-
Appointment order.
Bhaskar, same. Kumar affidavit.
Mm-hmm.
116, my lord. 116.
Where are you?
Yes, mostly. Sir.
It's only for only one day, that date was given, lordship. What are the queries, lordship, may kindly indicate?
Taken in presence. That is a man.
Lord.
My lord, it is there in the notice, so-called notice itself, man. And it was.
Prejudice. Presenting of.
In my presence, whether the. That's very important. On a hearing there.
23rd of July.
Hearing there.
Third, 23. There is a hearing there. That's
For further hearing.
highly of. Yes.
My lord, my signature was my signature was not collected even in my statement, my lord. Forget about my presence in. That I can't help, my lord. My reply, my lord, is very candid, my lord. But my signature was not collected in my statement, my lord. No. They cannot. No, I was not allowed to enter, my lord. I was not allowed to enter, my lord.
Getting oxygen from the honorable court.
That is how things develop, my lord. Much obliged, man.
Lordship, matter relates to compassionate department, Lordship, and SLC reject the case of the petitioner. Earlier, also petitioner was approached before this honorable court, Lordship, and the honorable, yes, Lordship. Lordship, that's Lordship. the court's order? SLC decision page 56, Lordships. Yes, Lordship. Not 13, Lord. 3/10/2015, Lord. 3/10/2015, Lord. Oh, yes, Lord. Yes.
Maybe next week, my lord, if. Yes, my lord. Lordship wanted only a clarification whether the statements of the borrowers were recorded. They were not recorded. My lord. Mr. Kostov Gugoi is there. I'll inform him. If
26/5/2005. Publish.
My lord, on the last date when Lordship had substantially heard it, Lordship had made a query whether the borrowers whose money was supposedly misappropriated or taken. Not exhibited, they were not examined at all. Their statements were not recorded.
But based on the documentary evidence, Lordship, they are supplied to the petitioner, Lordship. Report, Lordship. All documents are, I think, Lordship.
My lord. My lord. My lord. My lord.
Lordship, third week of year. Then when Lordship will available? 14 and 9 day. First week and second and third. Lordship on third week will come, Lordship, even after 1 year also it will come before Lordship.
My lord, could it be 23rd then, my lord?
23rd, we have no
23rd.
objection.
23rd. My lord. My lord.
I stand by it. Not there, Lordship. Accepted, he agreed, Lordship. Document.
Deeply obliged.
I'll try my best to, my lord, finish it. Yes, my lord, 15 minutes, my lord. No, my lord. 15 minutes, my lord, I'll finish. My lord, the petitioner before your lordships is the proprietor of College of Aeronautical Engineering, which is situated. Sorry. One case, my lord. Another is IA, my lord, wherein we have. The basic grievance is that we have challenged, my lord, 4 impugn orders dated 13. One is with regard to approval certificate issued in favor of GIET by the official respondents, that is DGCA. Basically, this is a renewal. GIET, that is full form is Gandhi Institute of Engineering and Technology, Orissa. Then second is same date, my lord, 13/8/2025, basic maintenance and training organization validity schedule. Sorry, my lord. A basic maintenance training organization validity schedule. Organization validity schedule. And another order of the same date, that is 13/8/2025, is 13/8/2025, is certificate of training. Yes, my lord. And the fourth one is 7/8/2025, by which one CD Panda, he was accepted as accountable manager, my lord. By respondent number 3. So these are the 4 orders which are under challenge before your lordship. Now, what happened in this matter, my lord? The petitioner is the proprietor of College of Aeronautical Engineering, which is of proprietor cum owner, my lord. Yes, my lord. College of Aeronautical Engineering, situated at Ranighat, Borjar. It was established in the year 2009. Two courses the institute provides to its students. One is aircraft maintenance engineering approved by DGCA.
maintenance engineering. It is approved by DGCA. And another is BSc affiliated to Gauhati University. General BSc affiliated to Gauhati University, my lord. So it's basically a 3-year course, which was imparted by this institute to its students, my lord. Sorry, my lord. No, it's a combined course, my lord. Yes, my lord. No. The course is aircraft maintenance engineering plus BSc, my lord. They will impart class in Gauhati University for BSc. My lord, that is how, because I feel, my lord, that is my instruction, my lord. All the, I'm sorry, I'm so sorry, my lord. The BSc classes will be imparted in the institute, but the course is affiliated by the Gauhati University. I'm so sorry, my lord. Two separate courses, my lord. That's how it's a graduate level course, my lord. No, my lord. No, it doesn't have any. My lord, the college was approved by respondent number 2, that is DGCA, on 8/6/2009 initially, my lord. Under CAR, that is Civil Aviation Requirement. There is certain set of rules, my lord, which are known as Civil Aviation Requirements, CAR it is. So under the those particular provision, it was first approved by R2 on 8/6/2019. Then annexure 8/6/2009. Sorry, my lord. I'm sorry. The approval certificate, my lord, will find page 27. This was annexure 1. Page 27, approval certificate, basic maintenance training organization. Pursuant to rule so and so and CAR 147 basic maintenance training organization for the time being in force and subject to the conditions specified below, DGCA hereby certifies MS College of Aeronautical Engineering NH 37 Airport Road Borja Ranigate Guwahati Assam so and so as training organization in compliance with section A of CAR 147 basic approved to provide training as listed so and so. Fine. Then page 20. Yes, page 28, examination not permitted. This was of 2021, my lord. Issued on 2021. Then, my lord, validity of approval, my lord, will kindly have page 29. It was valid up to 27 July 2025. In the name, this was given in the name of, my lord, Aircraft College of Aeronautical Engineering at Borja, my lord. Trade license, my lord, will find page 30. Then, my lord, what happened in the year 2024, the petitioner was not keeping well, as well as he had some issues in his family front and some litigations, because of which, my lord, he was unable to run the institute. Yes, medical as well as personal difficulties, he was unable to run the institute. He was not in a position, my lord. Some incident happened with him. So, he appointed one the petitioner, who was the proprietor and owner of the institute, he appointed one Dr. Chandra Dhwaj Panda as accountable manager. That, my lord, will find page 32, annexure 3. Page 32, Annexure 3. Dr. Chandradhas Panda, Odisha, Lordship has seen, my lord. Appointment as accountable manager. You have been appointed as accountable manager at College of Aeronautical Engineering subject to acceptance by DGCA. Your pay has been fixed and is already communicated to you, my lord. So the petitioner is the proprietor. He appointed the accountant manager. So accountable manager is like a manager in any other organization, my lord. He has right only to the extent of managing the affairs, and petitioner retains the ownership, my lord. Now, after that, my lord, there was a deed of declaration that, my lord, will find page 34. The petitioner entered into an agreement with Vidya Bharati Educational Trust. That is respondent number 5. Page 34, my lord. Dated 2nd March 2024. Lord, I'll just read some relevant portions in this agreement. Lordship will kindly mark. Between Sri so-and-so, son of Sri so-and-so, accountable manager, College of Aeronautical Engineering, Ranigate. At that point of time, he entered into an agreement in the capacity of accountable manager. Because appointed but approval did not come. So he acted as an accountable manager and he entered into an agreement with Vidya Bharati Education Trust. Now, in that page itself, my lord, last paragraph, whereas the said first party is the accountable manager of College of Aeronautical Engineering dealing with job of imparting, providing education, so-and-so, so-and-so. My lord will kindly skip DGCA, my lord. So, petitioner, only the proprietor can appoint an accountable manager. Accountable manager is like a general manager or any other manager in an organization, my lord. Yes. Now, last page 34, last paragraph, whereas first party is accountable manager, College of so-and-so, dealing with job imparting, providing education under name and style, College of Aeronautical Engineering, Gauhati, offering aircraft maintenance engineering approved by Director General Civil Aviation, and Bachelor of Science affiliated to Gauhati University, situated at Ranigate, so-and-so. Lord, now, Lordship will kindly come page 35, second paragraph. And whereas considering his health condition, the first party is facing difficulty in running the aforesaid College of the Aeronautical Engineering AME part. Second paragraph, fine, madam. Whereas the aforesaid College of Aeronautical Engineering under approval of DGCA reference number so-and-so per. Yes, yes. Whereas considering his health condition, the first party is facing difficulty in running the aforesaid College of Aeronautical Engineering AME part. He also made physically visit to the campus of second party. He is fully convinced, referring to NBA, NAC, ICR, Nursing Council accreditation, and based on this merit, the first party thereby agrees with the second party to hand over the aforesaid approval. My lord will kindly mark this. Hand over the aforesaid approval issued by DGCA under reference number 25/6/2021 in respect of aircraft maintenance engineering course to the second party for providing theory practical training under B11 subcategory to the concerned students. May I read after, my lord? And for the said purpose, the second party And for the said purpose, the second party hereby agrees to provide required facility, infrastructure, along with manpower to run the College of Aeronautical Engineering, Gauhati, at initial consideration of rupees 7 lakhs. Lordship will kindly mark this because I have got some submission with regard to this only. Now, in the next paragraph, whereas the BSc in Aeronautics offered by the College of Aeronautical Engineering, Milord, it was BSc in Aeronautics, Milord. I stand corrected, Milord. Whereas the BSc in Aeronautics offered by the College of Aeronautical Engineering under the Gauhati University shall be operated and run by the first party, and second party shall have no claim or privilege over the said course. Now, under this condition, what was actually done by is that, Milord, 3 employees or they came from Uri. Yes, Milord. I'll just explain what is the consequence of this. 3 persons came from Orissa, stayed here, trained those persons, simultaneously both the courses were going on, Milord. Now, this deed of declaration come acknowledgement witness as follows. That in pursuance to the aforesaid agreement and in consideration of the sum of rupees 7 lakhs, which the second party has made to the first party by check bearing number so and so, State Bank of India, Gunupur branch, Orissa, the second party with respect to payment of consideration against the handing over of approval license for running the Aircraft Maintenance Engineering College, the first party admits and acknowledges the sufficiency of consideration price. So it was considered that 7 lakhs, they will pay 7 lakhs. License was handed over. Then, my lord, that the second party on the strength, yes, my lord, that the second party on the strength of this deed may create, stroke establish, GIETU College of Aeronautical Engineering with a new accountable manager. Lordship will kindly mark this, my lord, to be nominated by the first party. So the accountable manager will always be nominated by the first party. And the first party shall have no claim whatsoever on the said business with effect from complete execution. Also, will mark this complete execution. And henceforth, the first party is no way liable, responsible for the affairs in connection with the College of Aeronautical Engineering AME branch. Number 3, the first party shall hand over all his powers and privileges on aircraft maintenance engineering of College of Aeronautical Engineering to the second party. Now, page 37. Page 37, Melu. The first party will nominate new accountable manager and designated post holder with relevant forms as applicable. The first party will nominate a new accountable manager. That on behalf of both parties, the new accountable manager, Lordship will kindly mark this, on behalf of both parties, the new accountable manager of GIETU shall apply to the DGCA for change of location from Gauhati to GIETU College of Aeronautical Engineering, Gunupur. So the sequence is that the petitioner will nominate the new accountable manager and new accountable manager will apply for change of location to the DGCA from Gauhati to Gunupur, my lord. That is the it's the terms of the agreement, my lord. Then serial number 7, the second party shall create a new bank account in the name of GIETU College of Aeronautical Engineering for all financial transactions related to its institute, which shall be operated by the new accountable manager nominated by the first party. Then serial number 8. The bank accounts of the present College of Aeronautical Engineering shall be managed and operated only by first party. And sorry, my lord. Yes. Yes, it doesn't specifically mention that BSc, but even then, I'm not giving much credence on this because it's already there, my lord. I have shown to your lordships, my lord. Then, my lord, page 40. Serial number 9. Serial number 9, my lord. Yes. The said first party having full right to hand over the said approval granted. Lordship will, from the very beginning, this agreement was only with regard to the approval, not with regard to the institute. Hand over the said approval granted by the DGCA hereby hand over to the said second party and will not at any time thereafter revoke, annul, and make void the aforesaid handing over hereby given to the said second party, and do or execute or knowingly or unknowingly suffer any act, deed, or thing whereby the second party may be prevented from having and receiving the said approval or any part thereof, or to and for his own use and benefit, or by means whereof the said second party shall be injured in the said business. Then, my lord, there is another agreement, page 40, my lord. Contents are almost same. Page 41, my lord, because it was a transfer of goodwill, my lord. Page 40, it starts same date, my lord, 2nd of March 2024. Page 41, serial number 1. That in pursuance to the aforesaid agreement and in consideration of the covenants and the conditions thereunder contained to be observed and performed on the part of the second party, the first party do hereby grant and assure unto and to the use of second party all the beneficial interest and goodwill of the first party in respect of the aforesaid approval issued by the DGCA under reference number so and so for running the aircraft maintenance engineering course carried on by the first party in respect of the aforesaid under the name and style College of Aeronautical Engineering, Gauhati, with all the beneficial interest. Now, page 42, it's identical to the previous agreement. Complete execution has to be there. Then page 42, serial number 6, my lord. 5 and 6, new accountable manager will be appointed, and 6, on behalf of the both parties, new accountable manager of GITU shall apply to the DGCA for change of location from Gauhati to Gunupur. So these are the basic two agreements. Then there is a declaration by the petitioner that your lordship will find page 46. It was also on the same date. Serial number 3. . that due to my health condition, I am facing difficulty in running the aforesaid college of so-and-so. Accordingly, I have decided to nominate new accountable manager for the said AME course and have been looking for a suitable person to nominate the same. Then, my lord, page 47, Sri Chandra Dhwas Panda was nominated. Serial number 5, my lord. That when I visited the aforesaid university so-and-so, on being impressed so-and-so, I have decided to nominate Dr. Panda as new accountable manager CAE for AME course under DGCA as he seems to be competent and eligible for the same. So he nominated the person in the agreement by giving a declaration. Now, my lord, lordship will kindly come to page 48, my lord. The DGCA Director of Airworthiness by this communication accepted the appointment of Dr. Panda as the accountable manager. Subject nomination of accountable manager regarding enclosed so-and-so, the Chandra Dhwas Panda shall be responsible for compliance of requirements as laid down in approved MTOE, interface manual SCAR and other instructions issued by DGCA. It is intimated that DGCA headquarters New Delhi letter number dated as stated above may be quoted as authority of approval. The acceptance issued by so-and-so dated so-and-so as accountable manager in LEP is hereby withdrawn with immediate effect. So by this, Chandra Dhwas Panda was accepted as accountable manager and the petitioner's accountable manager post was withdrawn. So this letter was 1/4/2024. In between, my lord, some anomalies had occurred in the institute, like the teachers who came from Orissa, they did not impart classes. Then they left for Orissa and they started imparting classes online. They said to me that they were permitted by the DGCA to impart classes online. So, taking into consideration all these anomalies, on 29/4/2025, the petitioner, my lord, issued a letter for removal of accountable manager. Page 49, my lord. Dr. So-and-so, I have appointed you as accountable manager of College of Engineering so-and-so. Yes. Then, my lord, it was same was intimated to the DGCA also, page 51. It was intimated to the DGCA that no, proprietorship was never given, my lord. Only the license, approved license was handed. Yes, the thing they wanted to do by the impugn order. I'll come to the agreement, my lord. Because one of my submission is that agreement, both the agreements are void at their behest. I'll satisfy your lordships. That will be my agreement. You cannot execute those two agreements, my lord. Prior to that, my lord, I'll just show your lordships how they have manipulated the things, my lord. So this is 2/5/2025, my lord, is an intimation to the DGCA regarding the removal of Dr. Panda as accountable manager. Then, my lord, will kindly come. Sorry, my lord. Yes. Page 53. By this, after his removal, my lord, the petitioner nominated himself again because he could not see the anomalies going on in the institute. So he said that no, again I nominate myself. Page 53. Then, my lord, page 57, page 54 is also another, my lord, yes, undertaking given. Then, my lord, page 57 was a representation indicating the, my lord, anomalies going on in the institute. Then, my lord, page 61 is the most important document, my lord. 1. The accountable managership of the petitioner was accepted by the DGCA. Acceptance of so-and-so as accountable manager so-and-so subject. Reference may kindly be made to your letter dated so-and-so as discussed with DGCA headquarters. The acceptance of Sri so-and-so as accountable manager of College of Aeronautic Engineering is being considered and accepted by this office. And in this regard, it is advised that the amendment in the maintenance training organization MTOE may be submitted through EGCA at the earliest for the necessary action. It was given by the Director of Aeroordinance for DDGER Kolkata. So, on 24/7/2025, the accountable managership of the petitioner was accepted. That means the other one, Dr. Panda, was no longer there. An accountable manager. Then in the meantime, they started this process or Milord design to shift the institute from Gauhati to Orissa, Gunupur. And accordingly, Milord, the petitioner in the capacity of accountable manager, page 62, wrote a mail. It has come to my knowledge that the College of Aeronautical Engineering has applied for a location change from the present approval location Gauhati to Gunupur, Orissa. The proposal may kindly be cancelled as the previous post holder to have committed numerous violation of CAR 147 and approved training manual. All the previous post holder of the College of Aeronautical Engineering have been terminated from their respective posts and hence their wrongdoing should not be entertained by your good office. Then the writ petitioner filed WPC 4650/2025. 4650/2025. When nothing was done or no action was taken on the representations of the petitioner, he filed a writ petition WPC 4650. It was Sasson 4650/2025. No, that order is not on record, but my lord, I'll just explain. This matter came up for motion on 13/8/2025. Listed on 13/8/2025 and fixed on 22/8/2025. On the same day itself, on 13/8/2025, when they came to know about the listing of the writ petition, they issued all the impugn orders on 13/8/2025. Yes. The impugn orders your lordship will find, thereafter a series of representations were there. I am not taking your lordship with those. This is again with regard to the same 65 heading, my lord, acceptance of so and so as accountable manager. It was a mail, my lord. By this, my lord, they wanted some information from us. After my acceptance as accountable manager, they wanted some information and documents from us, which we have submitted, my lord. That your lordship will find page 67 and the informations 68 onwards. The impugn orders, my lord, will find page 86. Subsequently, my lord, WPC 4650/2025 withdrawn because impugn orders were passed. So that was withdrawn. With liberty to file afresh, that's how, my lord, this writ petition is before your lordship, my lord. First impugn order 6868, no. Yes, my lord. It's 86, my lord. I'm sorry. This is, yes. Then, my lord, 87. Yes, well, page 86. This is in the name and style approval certificate, basic maintenance training organization. Yes. Given in the College of Aeronautical Engineering, GIET University, my lord, Gunupur. The certificate which was issued in my name, in the name of College of Aeronautical Engineering, to be situated at Gauhati, this certificate was issued now, same name, because they cannot change the proprietorship, my lord. The ownership they cannot change. Same name they are bound to keep. They have shifted the, my lord, institute from Gauhati to Gunupur, Odisha. Then page 87 is the validity schedule. This was also impugned. Then page 88. Location address, Gunupur. Basic maintenance training organization approval schedule. Rating B1, limitation aircraft. This is some category of training, my lord. Then page 89 is the writ petition order which was withdrawn with liberty to file afresh, my lord. Then the funny thing came, page 91, which is also impugned. Respondent number 3, he accepted CD Panda as accountable manager. My lord, how come? Who nominated him? Same person who accepted me as accountable manager, he now accepted Dr. Panda. This is the challenge. My lord, my first submission is that, my lord, lordship has seen the agreement, my lord. Everywhere it is written that the accountable manager will process any change of location or any course change, everything. I'll just, for the sake of repetition, my lord, I'll just take your lordships to those portions. Lordships has already marked this. Page 37. On behalf of both parties, the new accountable manager of GITU shall apply to GGCA for change of location, so and so, so and so. So the process is that the petitioner, who is the proprietor, he has got the sole authority to select and appoint the accountable manager. DGCA, my lord, they can refuse to give approval that I have nominated someone, Mr. A, to be accountable manager. That person is not qualified, or that person doesn't have the credentials to become an accountable manager. DGCA can refuse. Yes, Milord. So my first submission. Yes, Milord. Milord, I hope, Milord, I'm clear. My first submission is that, Milord, you being accountable, you have appointed me, DGCA appointed me accountable manager, because there is a process. DGCA cannot do on their own. So since the new accountable manager is the petitioner, how can you appoint DG Panda again as accountable manager without that process following, Milord, on your own? You don't have the, DGCA doesn't have the discretion to select and appoint the accountable manager. This is my submission, Milord. Even if we go by the terms of the agreement, because agreement itself confers power upon the petitioner to appoint the accountable manager, no one else, Milord. Since the respondents are so heavily relying on the agreement, Milord, the agreement itself provides that the petitioner proprietor can only appoint the accountable manager, and accountable manager will act on behalf of the proprietor like a manager in any organization. He will apply for change of location, then everything will go. And this will happen only when he remained as accountable manager. The moment the accountable manager has been changed to the petitioner, Mr. Panda was no longer the accountable manager. Therefore, all these impugn orders dated 13/8/2025 vitiated. And the appointment of accountable manager of Panda by order dated 7/8/2025 also vitiated, because there was no, Milord, approval by the petitioner. You are bound by your own agreement. So that is, Milord, to that extent my submission is. Now the most interesting part is that they are saying that the agreement is, I am bound by the agreement. Milord, my humble submission is that, Milord, the agreement is void ab initio because of the fact, I have never received that 7 lakhs rupees, Milord. Section 25 of the Contract Act, Milord, an agreement without consideration is void. The check was bounced. The agreement was executed on a consideration that I will give my approval license and they will in turn pay me 7 lakhs rupees. That 7 lakh rupees I never received, Milord. There is this communication clearly reveals that with reference to the trail mail, we confirm that there was no credit amount of rupees so-and-so in your account for the period so-and-so against check number so-and-so on account of College of University account number so-and-so maintained in our branch. Also, a check is valid for 3 months from the date of, there is no further credit of the amount so-and-so. When there is no consideration, Milord, if your lordships kindly take up the section 25 of the Indian Contract Act. So, the agreement itself is void and inoperable. So, in one way, these impugn orders were violated because of the provision, because of the fact that those were not processed by a duly appointed accountable manager having authority on one count. And second is that the agreement you are harping so on that on the strength of this agreement, we have transferred the institute. I'm sorry, Milord. Respondent number 5 and 6.
No, I think this is affidavit filed by authority man. 3 and 4 are there.
He is, Milord, respondent.
Only 7 lakhs, not only 7 lakhs. One time it was bound. Afterward, we have also paid, madam.
Four. I'm not replying.
7
Mobile
lakhs,
to Thomas.
it is, my submission is there, received by him. Now, if details are yes, my lord, how he is raising. How this amount was paid, and afterward, all details are required, if I can place it out. No, my lord, let us think, not my affidavit here. The agreement is itself speaks. Yes, my lord, absolutely. Absolutely. My lord, my affidavit is, my lord, by Rasmiranjan Nayak. Statement. Seven lakhs. Of course, it is a clear position. 7 lakhs is paid, and this is, my lord. Otherwise, also if on. Yes, yes, absolutely, my lord. I'm trying to, my lord, find out. Thus, contractual obligation created by virtue of the compliance of the terms by the both sides, my lord. Otherwise, why he would have given the accountable manager? Suppose if he had given and not received amount, he could have, my lord, cancel it out. Take it back, my lord. No item was made, and afterward, lordship can see that the details amount, my lord, amount. If that once we have also filed regarding that payment part. If you kindly see the detail of payment at a different level, we have paid 7 lakhs part. Lordship, so far the 2 lakhs, how it has been paid after bounce, Lordship, needs required instruction. Hello, disable, hello, Lordship, can you see for a moment in the other side? There is no such statement.
Milord, there was no such statement in the. I'm just placing. Milord, this contention was raised by respondent number 4 in their affidavit at para 7, page 97. Respondent number 4, who acted like a private respondent, they have filed a detailed affidavit saying everything. I'm grateful to them, Milord. Page there they have mentioned page 97. Milord will kindly turn up. I'll just explain. They said, no. Fantastic, Milord. Fantastic. Now, reply to this I have filed, page 173. Where from your lordship will get this thing? Page 175. Because at the time of filing of this affidavit, Milord, this I did not get this clarification from the bank. So I specifically said in this particular paragraph, para 5, denied that the deponent had ever received an amount of rupees so and so. This I got later, Milord, after filing of the affidavit. So it's an admitted factual position. Milord, civil suits, Milord, I'll show your lordship the prayer. One is with regard to the delivery of position. And another is, Milord, I don't know where from they have got the amount. Some 20 crore claim, my lord, that I'll deal with. Prayer page 263 is prayer of one suit for specific performance of their affidavit, my lord. Declare of declaration to the effect that the action, lordship's got, my lord. The action of the defendant to dispose the plaintiff from the suit premises on the very date, so and so, so and so. These suits have already become obsolete. Or they want to continue? Sorry, my lord. No, my lord. No. My lord, my submission is not that. My submission goes to the root of the matter, my lord. What I'll do, what I have done, what I haven't done, that is inconsequential, my lord. There is an agreement. You have done. Sorry, my lord. My lord, check the check. My lordships want to see the copy of the check. No, I received the check. I deposited in the bank. That the check was never, my lord. It was bounced, that only, my lord. My lord, this clarification, true. It's a major factor. My lord, this, yes, understand. Yes. Well, that I can show to your lordships. I'll just one small submission. One small submission. My lord, what is challenge in the present writ petition, my lord? Challenge in the fine, my lord. Yes, my lord. One aspect. My lord. Very, very much about. Yeah, even who are one judgment I'll show, my lord, on this point only, my lord. Almost on similar situation. It was taken. Photocopy or yeah. But my instruction is that the check was taken back, saying that no. Lordship will appreciate. Lordship will, that is, my lord, instructions that I have got over phone. That is, I am disclosing, my lord. My lord, lordship, had I would have drafted the writ petition, my lord. Lordship, I understand. I in my affidavit in reply to the respondent number 4, I have specifically said that I never received that 7 lakhs. Yes, my lord. That the deponent denies the correctness of the averments made in paragraph 7 of the affidavit in opposition, which are contrary to and inconsistent with the records of the instant case. page 175. That the deponent, para 5 Miller, the deponent denies the correctness of the statements made in paragraph 7 of the affidavit in opposition. That statement is not there, Miller. No, it's not an oral statement. It's an affidavit. Miller, I have said on affidavit. Miller, Roswell, I understand. Lordship will read, I'll just reading the mail once. No, Lordship will see. I got your Lordship's point. Lordship is thinking that I received, Miller, I'm not, Lordship, no. Lordship, no, Lordship wanted to, no, I'm so sorry, Miller. I'm not saying thinking, Miller. I'm just, yes. Who present Pitya Kosil Tare proof asana? Yes, I have seen that, Miller. I have received a check of rupees so and so. I'll just take, yes. Lordship is reading, my lord. I'm sorry. Page 36, yes, got it, my lord. Oh. 29/12. Sorry, my lord. On 2nd of March, 24. It was within 3 months, my lord. Had I would have encased. Lord, my instruction is that check has been taken by them. When I inform that you, yes, I understand. Correct. If I wait. No. Yes, well, yes. But only small clarification I'll have to give, my lord, if possible in the next week. I'm so sorry, my lord. Can it be in next week? If I'll just.
Our parties remain, my lord. My lord, after vacation, my lord, is possible.
Any day, Wednesday. Look, they wanted after vacation because they have
No, my lord,
contemplating
anytime
the
if
institute.
Any submission if we make, they make a create of doubt, my lord. This is not.
Fine. I'm highly able. No, I'll clarify everything. No, in fact, my lord, with all due respect, my lord, in fact, this fact should have been clarified before your lordship in the writ petition itself. My lord, sometimes, one second, sometimes we cannot help. Correct, my lord. Correct, my lord. True, true, my lord. True, so true, my lord. I'll clarify this, my lord. No issue. Because one instruction is absolutely clear that 7 lakhs was never deposited to my account. I'll show. My lord, I'll file an affidavit. Let them show. No, one more thing. Let them show from their account statement they have deposited 7 lakhs in my account.
Well, by them, my lord. They have to substance.
Let them show. Look, my instruction is the check has been taken away.
He has taken too close, my lord.
Too close,
For 7 lakhs. We are fighting for 7 lakhs. Yeah, absolutely. Lord, we are fighting for 7 lakhs, but the before civil too
Let them
more
check
than 2
from their
crores he has
accounts.
taken, my lord. Thing is that I mean,
5. No, it is respondent number 5, my lord. Further hearing, my lord.
this matter numbers of times. Can it kept as a part of
Deeply obvious. No, otherwise also accountable manager ground I have, my lord. No, I'll show 2 pages. There is a process. On that count itself, it goes. Even then, much obliged.
Yeah, praise the Lord.
After 4 weeks.
Yes.
26 from item. Item 26 from and 55 also same. Item 26 and
26 and 55. Yes, sir.
It will take some time, my lord. Okay. Lordship, can it be subject to your lordship? Lordship, subject to your lordship convenience. Can it be, can it be some other day, my lord? I mean, then, lordship. Lordship, fair hearing not because of the timing, my lord. Lordship has given me time, my lord. What has happened, my lord? Not because of timing. Lordship, not because of timing, my lord. Because, my lord, there is no. Lordship. No, Lordship, that day also Lordship has given me time, my lord. I am satisfied. Lordship. Exactly, my lord. I cannot say now, my lord, because, my lord, my lord, maybe some other day, my lord. Then, my lord. Maybe less, my lord. I'm not sure, my lord. Lordship, let me clear first, my lord. Fair hearing not against the on this honorable court, my lord. My lord, that Lordship is very much just the purpose of pleading to give the enable the adversary party know the opponent's case, my lord. All on a sudden they cannot give me the surprise, my lord. That day I was shocked and surprised, my lord, because my lord, there is no pleadings till date, last 6 years. No para was reply, my lord. No para was reply, my lord. No, that is not the argument, my lord. But another, my lord, submission made by London Film that, my lord, advertisement in the year 2012. There is no other submission made by London except the advertisement and prayer portion, my lord. Not about the other excess teachers, illegal teachers, unauthorized teachers, nothing, my lord. So, my lord, amounts to admission actually in strict legal sense, my lord. Kindly come, my lord, please. Page 14, paragraph 13, lordship of WC. That is my 7914, WPC 7914, my lord. That is page 22, paragraph 13, lordship. That it is stated that the petitioners, along with the other similarly situated teachers, Sibsagar district considered the committee under the name and style of Sibsagar Zilla Prohibition Patra Beton Bonchita Pathanik Shiksha Committee And Lordship. No, Lordship, Lordship. Lordship, Lordship. Lordship, Lordship.
These people, they have retired from service, Your Lordship, and they have not been paid because these are not be regularized. Your Lordship, now the latest judgment has come also. 6, 7. I will meet. Your Lordship, in August, month of August, Your Lordship. Yeah. No, Your Lordship, I'm coming on 13th. Your Lordship. 77. I just let me see the date, Your Lordship. Just let me see. Lordship may have it on 63 by 18th, if Lordship will have it. 18th of August. Latest judgment, Your Yes, yes. Your Lordship, is Sukhendu Bhattacharya versus that has overruled open. Yes, sir. 2-3. 5-2. 5-2-3. Your Lordship. Pilot, I deep level. My lord, item 63, my lord. Same. 15 is 15-7, my lord. 15-7. Same, but same. Regular pension, my lord. Regular pension, my master Baragar. My lord, 61, my lord, 61. Highly obliged, sir. Your Lordship, our beats 1886. I got confused.
Answer not against this honorable court, Lord. No, Lordship. But the grievance is against the respondent. No reply till date, my lord. My lord, not reply.
Item 27, 28, and 29. Should fix on 15th, my lord. Connected with the members are fixed on 15th of July. My lord. SCR is not found. Madam, the SCR was not found, madam.
So, 48 was plus 5. No, any other date.
My lord, supplementary 60. My lord, we have filed the affidavit in opposition to the affidavit filed by the respondent number 1 to 5 today. Yes, my lord, in the supplementary list. We have filed an affidavit in reply today, and we have served the copies as well. My lord, my daughter was treated in a bad manner, which led to her death, according to the CCS pension rules. And there was also an interim order that was passed on the first day itself, on 13/2/2025. So we have filed a affidavit in reply today. Yes, my lord. Yes, my lord. Yes, my lord. We have served the copies as of today. My lord, can it please be fixed in the next week? Bless you.
I don't know if you.
Well, item number 37, my lord, we have challenged the selection procedure. Item 37, we have challenged the selection procedure, my lord. If my lord is hearing some other matter today, my lord. Today, my lord.
Item 32 to 35. Lord, this honorable court directed the government authorities to give retrospective promotion to the petitioner way back in 2024. Did not give. We filed a contempt, that is item number 33. And thereafter, my lord, there is a prayer for interim protection. What happened? In the meantime, my lord, yes, yes. To override this honorable court's direction, they transferred me from my cadre itself. I filed a writ petition, that is item number, my lord, 35. 34 is, my lord, the transfer. Interim order passed earlier shall continue. My lord, no, my lord, in the last item number 32, there is an interim prayer. My lord, they are trying to now remove me from service. No, in item number 32, there is no. Because I took medical leave. There are interim orders operating deeply obliged. I'll try to upgrade my lord. I'm deeply obliged, my lord.
Before that, my lord, Lordship is very much aware, my lord. The purpose of pleading is to enable the adversary party to know the case of the opponent in order to have fair hearing. That's it. That is. And that is, before that, my lord, is a short online submission, my lord. So for fair hearing is concerned, my lord, the purpose of pleading is to enable the adversary party to know the case of the opponent in order to have fair hearing, Lordship. It is imperative that the party should Lordship. Lordship, Lordship, no, Lordship. Lordship. So all of a sudden, they cannot give me the surprise because no comments and no reply, my lord. Lordship. Nothing against this. No para was comment. My lordship, before that, my humble prayer, your lordship, kindly come to page, paragraph 3 of page 245. 245. There are three people. উপরে কোনটো আছিল বলাচোন 245. 245. 245 also. প্যারাস কোনো মিলিগুলি করছিল যে এটা ছিল সরি লছে ফুটা ছিল প্যারাস কোনো মিলিগুলি Paragraph 10. The deponent, instead of giving the parawise reply to the writ petition, at this stage deem it appropriate to disclose the stand of the department against the relief sought for in the writ petition. However, the deponent craves leave to Honorable Court to file a detailed paragraph-wise affidavit, it be Honorable Court directs. So without parawise reply, my lord, I cannot give a extemporary speech in the hearing, my lord. I don't know, my lord, what is their stand, my lord. This stand, my lord, taken, my lord, there initially all these cases was in series, my lord. A common affidavit file, my lord, that is not parawise reply, my lord. Subject matter may be the same, my lord, meta is different, my lord. Without knowing what is their reply, what I can reply, what I can take my defense. Lordship, that is not before parawise, my lord. It is common for all. On the all the cases figured. Lordship. Lordship and participate. That paragraph 13, Lordship. এখন কোন করে শাসন মূল আবার সঙ্গে লিখে পাওয়া হয়েছে না মোর লেখা কোন the reference fee is that I have served representation, my lord, on 26/5/14, 18/15, 38/15, 29/15, because advertisement of 20 on 12, my lord, I filed the case on 17, my lord. In between, my lord, lots of dharna, strikes, lathi charge, media interaction, everything, my lord. So that petitioner not sitting idle, my lord, then even, my lord, 9/11/15, 22/11/15, 9/12/15, 16/15, 9/10 representation, my lord. But every occasion in the since date of illegal categorization, the petitioner name is access discharge, the respondent authority has only been given assurance that their matters are under consideration, but practically nothing has been done in the matters releasing current and area salary date. The petitioner gave leave of this honorable court to furnish the copies of the above referred memorandum whenever furnish it. Then, my lord, 14. My lord. Or 2 copies I annex, my lord. 2 copies annex, my lord. And my submission, my lord, because from 2012, why I filed in 17 case in the year 17, my lord, I was not sitting idle, my lord. I was approached the department continuously, my lord. There was the strike, dharna and everything, my lord. That apart, my lord, without salary, the financial constraint, my lord, it was a bit delayed, my lord. It doesn't mean that from 12 to 17, I was sitting, my lord. My lord. 2012, I participated, my lord. My lord. Yes, yes, yes. Yes, yes. Lordship, that the participated. Page 362, Lordship. That was a not willful participation, but a forceful participation, my lord. No, they didn't ask, my lord. I applied. I disclosed, my lord. 362, no? Doesn't 362. 362. Lordship, page 362, Lordship. Lordship. Recommendation seeking clarification and seeking exemption from submitting necessary particulars in terms of the aforesaid advertisement, my lord. We the undersigned have honor to state that the aforesaid statement that we have to come to know the education department, Assam has constituted a skilling committee to examine the claims of the teachers who were illegally appointed and working continuously in the lower primary upper school in the state since 1990 to 2001. In the said advertisement, it is more particularly stated that the applications are invited from the persons who were appointed during the period of 91 to 2001 in different lower primary schools. In view of the above said, it is further. Lordship. Yes, my lord. In annexes are integral part of the pleading, my lord. Oh, sorry. Additional affidavit. Sorry, sir. I'm sorry, Lord. My lord. Have disclosed, my lord. Have disclosed, my lord. Which point, Lordship? My lord. These annexes, I clearly asked, my lord, whether we should submit. Lordship, annexes are the integral part of the pleadings, my lord. Question. So, my lord, my humble prayer here, Lordship, annexes are the integral part of the petition, my lord. Immediately we write down whether we should submit the documents and options are not illegal or illegal, my lord. Then, my lord, page 365, my lord. That elementary education Assam Kailibar director wrote to the district elementary officers. With reference above subject, I am to enclose here the copy of the representation of the elite, Dilip Kumar, so and so, against that. 360. 365, what's it? Not considered, not replied. Not replied. No, Lordship. Because Lordship, you are requested to direct them to submit their application as per advertisement, my lord. Although I oppose, my lord, whether we should. Which pair, my lord? 265. 365. The prayer of the petitioner cannot be considered. They did not consider, my lord. You are requested to direct them to submit their applications. Although before I file a representation that whether we should file or not, my lord, because we are not illegal and irregular, my lord. Even they are also not sure who is irregular and irregular, my lord. Lordship. So we file this application, my lord. Then it means, my lord, we are compelled to participate, my lord, not willingly, my lord. Participation has a. It is a. There are several appointments to be regular teachers, my lord. So far, is my lord, annexer, I have made annexers and the made paragraph also, my lord. Well, I have. Lordship. Lordship. Lordship, again, I am repeating, my lord. It is a fact that the recruitment process remain corruption. So many illegal teachers was appointed, my lord. That is admitted fact, my lord. Everybody knows, my lord. That because of the total teachers was 7737, my lord, that was not scrutinized, my lord. And Basel is 6022, my lord. So remaining become excess, my lord. So for 7737, incumbency list. Oh, I have no incumbency list, my lord. Okay. Incumbency list. We are not in any incumbency list, my lord. Or incumbency list, OBP teachers, founder teachers, all from 1538, 1538, my lord. Before that, my lord, case 322, lordship. Twenty-two, lordship. Sorry, 321, lordship, 321. I mean, excuse, lordship. That office name or number, lordship. The issue of irregularity and illegality appointed teachers in lower primary schools 1991 has drawn attention of the government from quite some time. Over 3,000 to 4,000 such teachers have claimed to be working in the lower primary schools. That's it. That the state cabinet has given approval on the proposal decided to principal to consider the who have been working since 1990 till date. After following the due process according to the judicial pronouncement. Judicial pronouncement they never respected, my lord. Then, my lord, 322, my lord. The committee will examine the list of teachers who working from 1991-2001 in different LPME school without any break. That was not followed, lordship. That was not done, my lord. Kindly come to page 328, lordship. The earlier was the executive order, this is an administrative order, man, which is subordinate to the executive order, my lord. The government of Assam Education Department has constituting a screening committee to examine the claims of the teacher who were illegally appointed working continuously from 1991 to 2001, my lord. That applications are invited from the person who were appointed period 91 to 91 in different organizations. Upper primary school are working without any break till date, but not getting salary since the joining of the only intermittently. This appears will have to be complete information. My lord, so far earlier memorandum association who was working 91 to 2001. Here will find, my lord, who are getting salary or not getting. They categorize two categories, my lord, getting salary, not getting salary. This word may be noted, my lord. Subsequent challenge, my lord. Challenge, my lord. Separately not challenge. It is annexed to the integral part of petition, my lord. It is already done, made up mind, my lord. I have no point to submit. Lordship. This point, my lord, getting and non-getting, my lord, it is not my earned qualification, my lord. It is imposed qualification. So for memorandum is concerned, my lord, continuously from 91 to 2001, my lord. Here they put, which is a subordinate executive order matter, getting and non-getting, my lord. And for that, my lord, because somebody to be a order, my lord, passed by the my lord. Old order, my lord, it's like the getting and non-getting, my lord. So, my lord. Understand? More copy. That will be awesome. Let it. It is an authoritative finding by the Honorable Justice B.K. Sharma, no? Honorable Justice B.K. Sharma, Lord. No, my lord. So for getting and non-getting, my lord, how it, so corruption started from that, my lord. My lord, no, authoritative finding, my lord. I'm not, my lord, I may be allowed to read out, my lord. From the above, second page, let's see. From the above, what was emerged is that without first finding out as to who are illegal and access these appointees, some teachers are paid salary, their salary, but on the other hand, petitioners are not being paid salary since 2006. There is nothing to indicate prima facie that my lord, my submission, my lord, there is without finding who is illegal and irregular. No, not for receiver. It's an authoritative finding, my lord. My lord. Yes, my lord. Lordship, not surface, Lordship. Lordship. RTI reply basis. Ito to ase clear na mo hui. Ito kata TTC no. Lordship, Lordship case 3. Lordship. Lordship tomorrow morning. Sir, I'm not keeping well. That's why I'm again trying. I get it. After tomorrow. Take it. Tomorrow, Lordship. I have some fun. Get paragraph. RTI reply to. Lordship. Lordship, page 383, Lordship. Volume, additional affidavit reply. 83. It's a reply of the RTL Lordship. The application right information consent. The definition of a genuine teacher as you put in the first RTL reply. Page number 383, Lord, paragraph 2, Lordship. Lordship. The paragraph 2, Lordship. No genuine teacher has been identified in Sibsagar district. Regarding continuity report. এখন কি? Yes. Well, regarding continuity report, continuity, regarding continuity. Continuity report আছে, continuity. Continuity তো কই আছিল? একেলগে যে কাম কৰি থকা বুলি Lordship. Page, Lordship, page 210, 210 and 11, 210 and 11, Lordship. Not one at home. Ready? 210 put. Lordship. One of the findings is we are a discontinued teacher, Lordship. Discontinued teacher. Against that, my lord. 210, my lord. This is I have relevancy because that it is I am challenging the findings of the screening committee, Lordship. This is the proof, my lord. Maybe recorded as a submission, my lord. Lordship, 215 is the same, my lord. It is given by the member of district elementary education officer, Mr. that working till date, Lordship. That is 16, my lord. 215, my lord. My lord, these are the first, my lord, member come district elementary education officers, member come additional deputy commissioner, the chairman come commissioner of Assam. My lord. Lordship, name video Lordship. Serial number. Lordship, No, this thing regarding that I am not discontinued teacher, Lordship. Therefore, till date I am working, Lordship. Kuntu. Lordship, it may be repetition. I forget, my lord. That total teacher was 7737. Not scrutinized, my lord. Then, my lord. Lordship. Lordship, I have Lordship, some citations we may supply, my lord.
One line, well, Lordship has passed in on.
Lordship, that
Are we
is
relying on a Lordship? What's on this? That? Because in that petition also. 14. There was no challenge. That is rule.
But my citation is, my lord, that is lordship is ever, my lord, regarding supernumerary post, my lord. It is judgment in RAM, lordship. Since I am a supernumerary post, my lord, irregular cannot arise, my lord. কিমান number কিমান? WBC. 677924. Oh.
IPF for 13. 13. Di ba pang my lord? My lord. My lord. My lord, I was not given the opportunity to file representation and my lord, and my lord. Yes, my lord. And an opportunity should be given to me so that I can bring my representation with the certificate issued by the government surgeon, my lord. So without giving an opportunity to me, you have just, at least I should go for review medical, my lord. My lord, item 23, my name may be recorded.
Some few citations, let's allow. Tomorrow, right.